due process safeguards renders the action arbitrary and unconstitutional. If your lordships may refer to flag 16 of the case compendium. Flag 16, para 629. It clearly states that right of an individual to exercise control over his personal data and to be able to control his own life would also encompass his right to control his existence on the internet. Thereby, the accused have a right to privacy, Your Lordship. Your Lordship, the first prong mandates that...
In the same para, it is said that it is not an absolute right.
Your Lordship, indeed,
How
Your
do you
Lordship.
reply to that? 629.
Your Lordship, there indeed are exceptions to it, that prevention and investigation, there can be a restriction on this right, but this restriction cannot violate a fundamental right to Article 20, Clause 3. It has been established in the Selvi versus Karnataka case as well.
And what the court means by saying that this is not an absolute right?
Your Lordship, this fundamental right is definitely not an absolute right.
It can be carved in the larger interest of the society.
Indeed not, Your Lordship. In the present matter, there wasn't such an urgency or a public interest in this matter, and thereby compelling for password is not the right approach by the police. There can be other measures like the least intrusive measures means, which has been established in the Puttaswamy judgment itself, that there could have been consent taken. The court could have reviewed it. Court could have supervised the such compulsion of the password or seizure of the devices specifically.
What are the grounds on which fundamental rights can be restricted? Right to privacy. What are the grounds on which they can be restricted?
Your Lordship, there must be a law, there must be a legitimate aim, there must be a rational nexus and proportionality. And it must be proportional, and the safeguards must be complied with.
Proportional to what? What is the concept of proportionality?
Your Lordship, in the present matter, like the seizure of devices, and the aim was in order to prevent future cyber crimes. But here, this proportional, it cannot be said to be proportional, as it is violating a certain other fundamental right in this present matter. That is why here in this present matter, it cannot be said that the action of the police was proportional to the fundamental right.
You think with the technological developments, old case laws like Nandini, Satpati and all, they become irrelevant? Because technology is moving at such a fast pace. In I think 78 or 79, we didn't have any such devices. Probably TV had also not made a beginning at that point. You think that those judgments become irrelevant?
Your Lordship, indeed not, Your Lordship. The principle remains the same.
What is the principle?
Your Lordship,
which is remained the same, irrespective of the evolution of technology.
Your Lordship, the principle of Article 20, Clause 3 states that like no accused can be forced to provide self-incriminating evidence. It has been upheld in various cases, and the same, since in this present matter, when someone is compelled to provide password, they have to mentally recall that particular password, and thereby this principle is still valid in this present matter as well.
Thank you.
Your Lordship, there are 4 prongs to this Puttaswamy proportionality test. The first, that there must be a law and a legitimate aim. In this present matter, even though statutory provisions authorize the police to seize the devices, they cannot be said that they can compel for disclosure of passwords, or they cannot violate the right of privacy. Your Lordships, judicial warrants ensure that there is sufficient reason to believe that intrusion into privacy is necessary for the protection of state's interests. And in this present matter, judicial warrants were even not taken. Your Lordships, in this case, the police's unfettered discretion in seizing the devices violates the Article 21 and the fundamental protection against arbitrary state action. Your Lordships, even in the Foundation for Media Professionals case, they have directed the government to draft and publish guidelines emphasizing that judicial warrants must be there to prevent arbitrary digital intrusions. The second prong of the test here ensures that law which imposes the restriction falls within the zone of reasonableness and does not suffer from arbitrariness. Your Lordship, while the police aim was to investigate the crime and find evidence is a legitimate state aim, a blanket seizure of all the devices from all the members of the group, including those who were merely the recipients of the content and not are rationally connected to the aim.
How can we reach that conclusion beforehand that these are only recipients unless the police is given the opportunity to examine the devices? The issue cannot be prejudged.
Your
So
Lordship,
keep in mind a fact, like in a normal offense, if a knife used in the occurrence, certain occurrence, say murder or attempt to murder, is seized, right? And it is the police's job to investigate whether this knife was used in the occurrence. And if the fingerprints are taken and the sample fingerprints from the accused are taken to match, can he claim a similar right as you are canvassing? And what would be the point of distinction then? Because a password is a fingerprint, akin to a fingerprint that a person has placed to identify the instrument or the device as his own.
Your Lordship, the council does not agree to that statement.
You have a perfect right to disagree, but you have a duty to convince.
Indeed, Your Lordship. Your Lordship, in the Kathi Galu case, it had been this case was restricted to the physical specimens, including fingerprints or other biometrics, but this was for the purposes of identification. And in this present matter, when we compel to produce a password, that is not merely for the purpose of identification, Your Lordship. They are asking to produce the self-incriminating document via that digital devices in which the accused, in which the investigation has been filed. So thereby, it is separate. It cannot be stated that the physical evidence is equivalent to the compulsion or disclosure of password because it requires a mental recall. And it cannot be held.
How can we now say it's a password is a mental recall? With the technology, as brother has suggested, advancing, now you have face IDs. Tomorrow we are going to have IDs recognition with the retina identifications. How can we insist on this old test, which is a new test, which is really becoming obsolete because of advancement of technology already? So why not rely on the classical test
Your
of
Lordship,
fingerprints?
Your Lordship, in order to obtain certain documents or other measures, like in this particular matter, a social media group was there. The intermediaries could have been asked. The police could have asked the intermediaries. The social media.
Police may ask or may not ask. That is not for us to monitor how the police investigation officer will proceed in a certain matter. That remains his domain. So when you are questioning the action as violative of fundamental right, why should we not look at it with circumspection, allowing the investigation officer a freer hand to collect evidence unless a grossly disproportionate action is being taken? So, seizure of a phone or asking you for a password, it is open to them to even hack it open. That is a possibility. But to go clean for the investigating officer to ask you is to also help you participate, that you have cooperated, you have given the password. You cannot then suspect that something has been pushed into your device later. So there is more transparency in this making you participate. What is the objection? Because you're not being arrested at the moment. Disproportionality is...
Your Lordship, the accused are arrested.
Yes.
Your Lordship, compelling in this present matter, the Moot proposition clearly states that in paragraph 16, the concerned individuals have challenged the investigation for objecting to the confiscation and checking of the electronic devices. In this present matter, these have not been done with the proportional safeguards which are required in this present matter.
Please proceed.
Much obliged, Your Lordship.
Just one more question.
Indeed, Your Lordship.
You relied on a judgment of the US courts,
Indeed, Your Lordship.
which was referencing the Fifth Amendment.
Indeed, Your Lordship.
What is the difference between the Fifth Amendment and Article 20?
Your Lordship, Article 20, Clause 3 explicitly Article 20 Clause 3 explicitly states that the accused shall not be compelled in order to provide self-incriminating evidence. But the Fifth Amendment is a larger amendment, and it states that it also protects the accused from prosecution prosecuting against them twice in the same offense, or the self-incriminating that they cannot be self-incriminated. There are various other sections which has been incorporated in the Indian Constitution. So it is a larger amendment or law.
It is a larger amendment.
It includes various other laws, and in the Indian Constitution, these other laws have been.
So the provisions are not pari material, not the same. Can you rely on judgments where the facts are not the same?
Your
Or the
Lordship,
statute is not the same.
Your Lordship, one aspect of the Fifth Amendment clearly states that the accused cannot be forced to testify against himself. That is why it is pari materia to Article 20 Clause 3.
Thank you.
Much obliged, Your Lordships. If Your Lordships are satisfied with the second issue, the Council seeks permission to proceed to the third issue.
Yes.
Much obliged, Your Lordships. Your Lordships, issue 3 states that mere membership in the social media group without actively circulating or reposting the defamatory deepfake videos or images cannot attract liability for defamation, identity theft, or other cyber offences. And the same will be discussed to Your Lordships in a twofold manner, stating firstly, it lacks the requisite criminal evidence of actus reus and mens rea. And secondly, imposing liability solely based on a group affiliation infringes the fundamental right to freedom of association under Article 19 Clause 1c. If Your Lordships may refer to the appellant's memorial, page 8, the principle of individual criminality requires proof of both guilty mind and a guilty act for any offence. Passive membership or mere receipt of content in a group does not constitute either of these essential elements to constitute a crime. To attract liability under these sections, the accused must have a malicious intent and also a guilty act in order to constitute that there has been an offence. Your Lordship, there is a threefold argument in this present matter. There are three categories of people: the admins, the passive members, and the active members who actually circulated that particular video. Your Lordships, it has been held in various judgments, especially if Your Lordships may refer to flag 17 of the case compendium, the case of Kishore Tarun versus State of Maharashtra. Your Lordships, it held that in the absence of any specific penal provision creating a vicarious liability, group admins cannot be held liable for others' post. So, Your Lordship, in this particular manner, the group admins cannot be held liable if a certain particular deepfake video was being circulated within a social media group. Secondly, Your Lordship, there are passive members in this group as well. Your Lordship, there are members who have just viewed that particular deepfake video, who have not even reposted or circulated that particular video. They are being challenged in this particular investigation that they are to be held liable. But Your Lordship, if Your Lordships,
Please continue.
Your Lordships, in this particular case, even they are to be held, but the councils plead that when there is an absence of mens rea or even the actus reus in the present matter, they cannot be held liable for a certain video within the social media group. Your Lordships, the council seeks permission to call upon the co-counsel for the next issues. Much obliged, Your Lordships.
The council seeks permission to proceed with issue number 4.
Yes, please.
Much obliged, Your Lordship. Lordship, issue number 4 states that sufficient link does not exist between circulation of deepfake video and the subsequent cyber fraud. Your Lordship may refer to para 7 on the Moot proposition, page number 2 of Moot proposition, para number 7, Your Lordships. In the second line, it is written, on 19th July 2025, a social media group titled Techies circulated deepfake videos and photos of Mr. A collecting cash from someone at DG Port. In the next para, it is written, later that day, Mr. A was suffered from a cyber attack. Now, Your Lordships may refer to para 9 of the Moot proposition. Next page, Your Lordships. Therein, FIR has been alleged against three distinct persons. First, admins of the techies group and their members. Second, social media users. And third is those who conducted the cyber fraud. So there is a clear distinction between those who circulated the deepfake video and those who did the cyber attack. So there is no rational link between those who circulated the video, that are the appellants, and those who are accused in the for cyber fraud. Now, this argument is satisfied in a twofold manner.
No, so your submissions are with respect to all four categories or just one?
Your Lordships, we are the appellants. We have argued, we are the circulators of the deepfake video, alleged circulators of deepfake video, and we are not the accused persons named in the FIR.
So once you
We are the accused persons.
once you admit that this is a deepfake video, what right exists in your favor to ensure that it stays available to any viewer for any purpose whatsoever? If it is deepfake, it's deepfake. Why should it all be allowed to exist?
Indeed, Your Lordship. It should
If you are
not,
disputing that it is a deepfake, then it would be another thing.
indeed not, Your Lordship. What we are disputing is the factum of knowledge. At the time of circulation of deepfake video, we did not know it was a deepfake video. So even if there is circulation, even if there is liability for circulation, it is purely civil liability, because the idea of mens rea, that is the guilty mind to circulate a deepfake video, is not present.
But issue number 4 is against an injunction.
Indeed, Your Lordship.
So injunction is against continuance of material remaining available and there being a possibility of it being further circulated. So if an injunction operates against a deepfake, what right can any party have against such an injunction?
Your Lordship, there are two different issues. First of all, in issue number 4, we are arguing that circulation of deepfake video and the subsequent cyber fraud, the perpetrators of both the incidents are not related. In issue number 6, we are arguing that the ex parte injunction granted by the High Court is not justified and unenforceable.
Just one minute.
The liability, considering today's digital age, you think that it is the responsibility of the law, the process of the law, to ensure that all citizens who are handling digital media have to exercise due diligence before circulating the videos.
Indeed, Your Lordship.
So what diligence, if you've not taken out those steps of due diligence to confirm the authenticity of the video, why shouldn't you be non-suited, as they say?
Indeed, Your Lordship. Your Lordship may refer to the IT Act provisions, wherein liability for circulation of fake videos or something like that is fixed on the intermediary, not the circulators of the video and not the the admins of the group. It is fixed on the intermediary.
Which provision?
IT rules. Just a moment, Your
Your
Lordship.
colleagues can look into that. In the meantime, you please continue.
Indeed, Your Lordship. Lordship, my first argument was there is no sufficiency of link between circulation of deepfake video and the subsequent cyber fraud. There are two basic reasons for that, Your Lordship. First of all, there is absence of criminal nexus between deepfake circulation and cyber fraud. Now, I have argued before Your Lordship that those who circulated the video and those who conducted the cyber fraud are two distinct persons, as already named in the FIR. So, in Sharad Birdichan Sharda versus State of Maharashtra, Your Lordship, Lordships may refer to flag number 32 of the compendium.
Yes.
Flag number 32, para 153.
Yes.
It is a Supreme Court judgment wherein the Supreme Court held that in cases of circumstantial evidence, the circumstances must be fully established to form a complete chain such that it is consistent only with the guilt of the accused. Lordships may refer to page 11, para 34 of the Moot Memorial, Your Lordships. Moot Memorial, Your Lordships. Page 12, para 34, Your Lordships. In the third line, the VIF report on Bharatiya laws against deep cyber crime highlights that while deepfakes enable fraud, prosecutions require beyond doubt linkages, not assumptions, due to the complexity of proving possessions. So, what the police have done is they have linked the circulation of deepfake video with the cyber fraud. What they should have actually done is to analyze.
Just a minute. Are we not prejudging the issue or ahead of the stage of the proceeding? When you are stating that this is based on circumstantial, we are only at the stage of investigation. Where is the question of stopping the investigation or quashing the FIR on the principle of Sharat Dirdichan, that is a principle to be applied at the stage of trial. That has yet not reached.
Indeed, Your Lordship. However, under Section 528 of BNSS, the accused persons have a right to approach the court and request for quashing of FIR if the offence is prima facie not made out. Now, when there is no criminal nexus or criminal act assigned to the appellants, then there is no need to conduct an investigation under Section 528 of BNSS, Your Lordship.
See, at times, there is what they call as a FIR, which is an unnamed FIR. An offence is disclosed, but the offenders are yet to be identified.
Indeed, Your Lordship.
So can a person who's not named in the FIR come before the court and say that no offence is disclosed and therefore the FIR ought to be quashed?
Indeed not, Your Lordship. Only the accused persons can come before the High Court. Now,
Suppose a person is facing threat, the investigation of threat of arrest. Can a person come to the High Court saying that there is a legitimate reason for me to believe that I am facing a threat of arrest?
indeed, Your Lordship, there is provisions for anticipatory bail application to be filed before the courts. And in the instant case, Your Lordship, in the FIR, two distinct persons have been named. Two persons have been named for circulating the deepfake video, and other persons have been named for causation of cyber fraud. So there are two different persons. One is circulator of video, and another is causation of cyber fraud. So even if there is any liability for circulation of deepfake video, it is purely civil in nature. And those persons who cause this cyber fraud, criminality is for them only, and not the circulators of deepfake video.
See, cyber fraud on its own will be of no avail till it is circulated. Suppose someone has created some sort of a fraudulent cyber document or a deepfake video, and he keeps it to himself, insulates it from circulation. But the other person is party to the circulation. So what the investigation officer is seeking to do is to see whether there is a live nexus between the circulation and the creation of the deepfake.
Indeed, Your Lordship. What we are arguing, in the present facts, nowhere mention is that who produced the videos. So we do not know who produced the videos or whether the circulators were actually, and circulators were not in knowledge that this was a deepfake video. So in the present facts, what video was received is Mr. A, who is a customs officer, receiving bribes. So this was an argument for innocent circulation, Your Lordship, without absence of mens rea. They did not know that the video was actually deepfake. So unless and until they had a guilty mind to actually circulate a deepfake video, no criminal liability can be fixed on them. Only liability that can be fixed for them is violation of privacy rights and personality rights, and that is purely civil in nature, Your Lordship, not criminal.
All right. Let us compare this to a very simple situation. There are 3 students sitting in an examination hall. One is writing his answer on his own. The third is asking for what we call material to write. He asks the second to in turn ask the first one to share some information to him. The second innocently passes it on. He is not attempting that question. So can this issue be prejudged whether when the evaluator or the examiner or the what are they called? The invigilator observes that there's cheating in the examination hall. How does he react? Does he let the second go because he was not attempting that answer?
Indeed, not, Your Lordship. In the present facts of the case,
So why is it that situation not comparable here? Somebody who has a deep fake receives sense.
Your Lordship, we are talking about criminal law, where the burden of proof is very high. It is beyond reasonable doubt. So the police has to establish not only that they circulated the deepfake video, but they circulated it with a criminal intent. That is, they wanted to circulate a deepfake video with a guilty mind. Actually, there is the burden of proof is higher, Your Lordship. Moving further, Your Lordships, Lordship may refer to again para 34, page 12, where it has been argued that the sequence of events lacks the requisite chain as temporal proximity alone permits innocent explanation. In the instant case, Your Lordship, there was a circulation of deepfake video. Now, later that day, cyber fraud took place. It is not stated that the cyber fraud took place immediately after circulation of deepfake video. So the deepfake video was circulated and many people viewed it. So it is possible that any person from the web caused cyber fraud. So in this situation, when there is no nexus established that the cyber fraud took place immediately after the accused, after the circulation of deepfake video, criminality cannot be established for circulators of deepfake.
Where is the definition of cyber fraud? In which provision? You are being investigated under which provision of law?
Your Lordships, we have been alleged of offences of identity theft under Section 66C of the IT Act.
Yes.
For impersonation under Section 66D of the IT Act. For criminal conspiracy under Section 61 of the BNS.
Yes.
For wrongful confinement under Section 127 of BNS. For cheating under Section 380. And for forgery for the purpose of cheating under Section 336 Clause 3.
Right. Please continue.
Much obliged, Your Lordship. Your Lordships, further, the Council humbly argues that the grounds of quashing investigation in Section 528 are satisfied. Now, Your Lordships may refer to flag number 37 of the case compendium, Your Lordship. In State of Haryana versus Bhajan Lal, the Supreme Court held that quashing can be ordered if allegations do not constitute any offence or are absurd or inherently improbable. Now, when criminality or cruelty act cannot be assigned to the appellants, there is no offence made out against the appellants in the instant case. So, Section 528 grounds are satisfied. The only link that is criminality is fixed is by linking the circulation with the cyber fraud, where there is no link exactly existing. There is innocent explanation permissible. So, the grounds
Can the case of the defense be examined at this stage? The Bhajan Lal test. What does it require to be seen by courts? Is it the defense case to be seen? Is it the prosecution case in the FIR contained in the FIR alone, or is it the FIR and the charge sheet material or the case diary?
Your Lordship, at the stage of investigation, only the FIR is seen whether the allegations made in the FIR prima facie made a case or not, or whether they are inherently absurd or inherently probable. So these three are seen at the stage of FIR.
So your case that you are saying that I have not circulated, isn't that premature to see at this stage? You may be right on facts that you have not circulated, but you are asking the High Court to quash the FIR at the initial stage, not allow it to be tested at the trial stage.
Indeed, Your Lordship.
What my brother is saying is that the offence has two components. One is the creation of the cyber fraud, and as a marketing wing, you were circulating that. So that, whether you were part of the marketing wing of the cyber fraud creation gang, is a matter which only the investigation can determine.
Indeed, Your Lordship. What the Council is humbly arguing that in the instant case, there was a circulation of deepfake video. We accept that. Even if there is circulation, there may be civil liability, but no criminal liability. Secondly,
What civil liability? What do you mean by civil liability?
civil liability can arise under personality rights, Your Lordship, under right to privacy under Article 21. Personality rights are protected for the persons, and no person can be allowed to violate the personality rights such that it violates the defamation or.
You are circulating something which has trapping of a criminal offence, and you say it is a civil right. How it can be a civil right?
Due to absence of mens rea, Your Lordship, we have circulated.
That can't be decided without investigation.
Indeed, Your
Whether
Lordship.
you had intention or not.
Indeed, Your Lordship. The facts clearly state that we circulated the video. It does not state we produced the video. Neither does it state that we circulated the video with a criminal intent.
Right.
Furthermore,
That would be seen after investigation.
So, right, please continue. So you think civil proceedings on the same cause and criminal prosecution on the same cause can continue simultaneously? Or your argument is they can't?
yeah, indeed, Your Lordship, they can't. This is my fifth issue, Your Lordship, wherein Your Lordship may refer to flag number A of the compendium.
A.
Indeed, Your Lordship, A.
Alpha. Okay. It is in two parts.
We had added the flag later, Your Lordship, where apologies, Your Lordship.
That's fine. Just let us see. So it is
Flag,
after
flag.
which flag?
A. Flag number A.
A appears after which flag? It is at the top.
Well, you should ensure that the flagging is proper when
We
you're
are-
coming before a full bench.
We seek sincere apologies of Your Lordship. Your Lordships, I may cite the line that is stated in that judgment.
Yes, you read the line.
Please give the citation first.
Indeed, Your Lordship. Your Lordships, in Karamchand versus Union of India, the Supreme Court held that civil court decisions are binding on criminal court, and that it is not vice versa. So when the civil matter is already pending before the division bench, then the criminal proceedings can be halted for the time being. The citation of the case, Your Lordship, is 1973 SCC.
Yes, we have found it. It is at page 103.
Yes.
Indeed, Your Lordship. Your Lordships, further, if you refer to citation flag number 26 on the compendium. Flag number 26,
Yes.
para 29, Your Lordship. It is again a Supreme Court judgment of Professor R.K. Vijaysarathy versus Sudha Sitaraman, wherein the Supreme Court held that there is an abuse of process when there is an attempt to cloak a civil dispute with a criminal nature, despite the absence of necessary ingredients of criminal law. In S.N. Vijayalakshmi versus State of Karnataka, again at compendium citation flag number 28, the Supreme Court held that concurrent proceedings absent criminality upon to abuse. Now, in the previous issue, I have argued that criminal liability cannot be established on the appellants. So the allegations against the appellants, if any, is purely of civil nature. So when the allegations against the appellant is purely of civil nature, then criminal liability is not there. Then there is an attempt to cloak the civil dispute with the criminal dispute. So in light of these judgments, the criminal proceedings should be halted for the time being, as long as the civil proceedings are continuing.
But is it not a equally settled principle that arising from the same transaction, civil and criminal consequences can arise, and both should be examined in the context of the own laws that govern them?
Indeed, Your Lordship, this is an established principle. However, if the dispute is purely of civil nature, as in the instant case, then criminal proceedings cannot be allowed to continue. We have already established before Your Lordships that the disputes in the issue before the allegations are purely civil in nature. So there is an attempt to convert the civil dispute into criminal dispute with the motive of harassing the appellants. So there is an abuse of process by cloaking civil disputes with criminal nature. So the civil criminal litigation should be stopped.
Not.
Lordships may also refer to para 14 of the memorial.
1-4.
Yes, indeed, Your Lordship. Page 14, para number 41, Your Lordship. First line. In parallel civil litigation, the US perspective. Are Your Lordships with me? Page number 14, Your Lordships.
Yes.
First line, para 41, Your Lordships. In parallel civil litigation, the US perspective, it has been argued that simultaneous civil and criminal proceedings on overlapping facts risk conflicting judicial findings, particularly on deepfake authenticity, liability, and the criminal nexus to fraud, prejudicing the petitioner's right to fair trial under Article 21 and necessitating a stay to ensure judicial consistency. In Lordship, in MS Sharif versus State of Madras, the Supreme Court held that when the civil suit is near its end, the criminal prosecution should be stayed. In the instant case, the civil suit is already before the division bench of the High Court. However, the criminal prosecution is under investigation
At
stage.
what stage is the civil suit before the division bench?
Your Lordship, we had...
Is there a final decree in favor of any person in the civil suit, or is there only an injunction order?
An injunction order has been granted by
Then
the...
how can you apply this principle?
Your Lordship, the civil suit is already before the single judge bench of the High Court, is already in the prosecution stage and is already on the trial stage.
An injunction stage. Evidence has yet not been laid. That is not there in the...
Indeed, Your Lordship. However, the civil suit is nearer to its end compared to the investigation. The investigation will conclude, a charge sheet will be filed, then charges will be framed, and further evidences will be taken. So, comparing the both of them, the civil suit is nearer to its end than the criminal proceedings. So, applying the MS Sharif...
So are the standards of evidence which are applicable to civil and criminal proceedings the same?
Indeed.
What standards of evidence are applicable to criminal proceedings?
Your Lordship, the standard of evidence is proof beyond reasonable doubt.
And in civil proceedings?
Preponderance of probabilities, Your Lordship. So the civil proceedings is likely to complete faster. Furthermore, the accused persons are already arrested by the police. So what we need is halting of the civil criminal proceedings so that the accused appellants can rightly present their case before the High Court without any problem, Your Lordships. Without any harassment and problems, Your Lordship. Lordship, if Your Lordships are satisfied, Council seeks permission to proceed with issue number 6.
Yes, please.
Much obliged, Your Lordship. Lordship, issue number 6 states that the ex parte injunction granted by the single judge bench of the High Court is not justified and is not enforceable. Now, In the instant case, Your Lordships may refer to para 10 of the proposition, Your Lordships. Para 10 of the proposition. Page number 3, Your Lordships. Page number 3, para 10. Parallelly, Mr. A has approached the High Court of Innovate by way of a civil suit seeking protection of his name and image against misuse. In para 12, Your Lordships. Seeing merits in Mr. A's case, the High Court decides to grant an ex parte injunction. Now, Your Lordship, in the personality rights suit filed by the defendants, an ex parte injunction order has been passed by the High Court. What we are contending is that this ex parte injunction order is not justified and is not enforceable for 3 basic reasons. First, violation of audio alteram partem rule and ignorance of procedural safeguards, Your Lordship. Your Lordships, in JM Sheikh versus Rajawadi, flag number 12, Your Lordships. Flag number 12, para 5. The Kerala High Court noted that ex parte injunctions without notice to defendants to be too adventurous and cautioned against it. Under Order 39, Rule 3 of CPC, ex parte reliefs can be granted only when clear and tangible reasons are provided in the order. Now, in the instant case, Mr. A applied for an ex parte interim injunction. The High Court, without assigning any reasons, without giving notice to the appellants, passed an ex parte injunction order. Order 39 Rule 3 mandates that if there are reasons existing for not granting notice to the opposite party to defend their stance, then reasons should be recorded in writing. But the High Court did not assign any reasons as to why it did grant ex parte injunction. What the High Court could have done is issue a short notice to the defendants. The appellants could have been called through video conferencing, but the High Court did not do so. It was in blatant violation of Order 39, Rule 3 of CPC, Your Lordships. Further, Your Lordships may refer to flag number 22 of the compendium, Your Lordships.
Yes.
This is a Supreme Court judgment of Maria versus Erasmus, wherein the Supreme Court held that it is a safe and better course of action to hear both parties before granting ex parte injunction. The High Court did not make any effort as to why ex parte injunction should be granted. The notice to the appellants was not issued. So in this case, the ex parte injunction granted by the High Court should be vacated. Now there is another reason as to why the counsel requests extension of 2 minutes to complete arguments. Much obligation, Lordship. Lordship, the another reason why this ex parte injunction should not be granted is because it exceeds judicial power and violates Article 19(1)(a). In Shreya Singhal versus Union of India, Your Lordship, flag number 35, Your Lordships, the Supreme Court held that injunctions on digital content must be narrowly tailored to specific harms, otherwise it may lead to chilling effect. Now, what the High Court has done is granted blanket restrictions on the appellants to not use anything of Mr. A, and this was not narrowly tailored. Your Lordships, the single...
We asked you, do you say this is a deep fake or not a deep fake?
Your Lordships, at the point
If you are admitting it's a deep fake, where is the occasion to allow you to circulate it and commit a criminal act then? Now you are fully aware that this is a deep fake.
Indeed, Your Lordship.
But how are you aggrieved by the injunction?
We are aggrieved by the ex parte order, Your Lordship. The order was passed ex parte without providing any opportunity for the defendants
But what is the prejudice caused to you?
The prejudice caused to is violation of Article 19(1)(a). It causes a chilling effect on petition,
Does
right.
anybody have a fundamental right to commit an offence?
Indeed, not, Your Lordship.
So that is why we are asking you, what is your stand on the deep fake?
Your Lordships.
Once you say it's deep fake,
then the injunction is
Either
right.
you get relief in the criminal case or you take relief in the civil side. You can't have your cake and eat it too.
Your Lordship, at the time of circulation, we had no knowledge that it was a deep fake video. Now, when the ex parte injunction is granted, now there is a third reason as to why this ex parte injunction should be vacated. That is absence of sunset clause. Your Lordships, in Morgan Stanley versus Karthik Das, the Supreme Court held that ex parte injunctions should be granted for a limited period of time. In another case, Maria versus Erasmus again, the Supreme Court held that ex parte injunctions should be granted only in grave urgency, and that too for a specified period, say for 2 weeks. In Rama Rameshwari Devi versus Nirmala Devi, the Supreme Court held that 7 days injunction period would be appropriate. Again, in Maneka Gandhi versus Union of India, the Supreme Court provides that even if pre-hearings cannot be provided, instant post-hearing should be provided to hear the side of the appellants or the defendants in that case. In the instant case, none of these rules were complied with. Further, Rule 3A of Order 39 of CPC mandates that the court should decide on the after the grant of injunction, it should be decided again or reviewed within 30 days, which is not there in the instant case. In the instant case, the High Court single judge bench has granted ex parte injunction without providing any specific and short date for review and representation by the appellants. This violates procedural safeguards and risks prolonged enforcement, thereby intruding upon Article 21. If your lordships are satisfied, counsel seeks permission to proceed with prayer. Much obliged, your lordship. Wherefore, in the lights of the facts presented, issues raised, arguments advanced, and authorities cited, the counsel on behalf of appellants humbly prays before this honorable court that it may be pleased to adjudge, hold, and declare that the coercion by police to disclose passwords violates Article 20 Clause 3 of the Constitution, that the police accessing and searching the electronic devices of the accused violates their right to privacy under Article 21 of the Constitution, that mere membership in the social media group cannot attract liability for defamation, identity theft, or cyber offences, that sufficient link does not exist with the circulation of deepfake video and the arrest of the cyber accused under cyber and criminal laws, that the criminal investigation and prosecution cannot continue when the civil suits concerning the same facts are subjudiced before the division bench, that ex parte injunction granted by the High Court restraining the use and sharing of Mr. A's image is not justified and unenforceable, or pass any other order decree that the court deems fit in the interest of justice, equity, and good conscience, and for this act of kindness, your lordship, the appellant shall be duty bound forever. It was an honor to argue before your lordships.
Thank you.
May it please this honorable court, before I officially come upon the dais in respect of the certain formal introductory, I am speaker 1 of Respondent and I am assisted by my co-speaker and he is our researcher. We collectively form the body of counsel representing the Respondent.
Yes.
Lordship, we have taken over a party representation because there are two respondents, Mr. A and the state. So, and there are 4 issues. In our memorial, you will note, please confirm if you have our memorial. The red one.
Yes.
You will note that, and I am representing Mr. A and also the state for one of the issues. My co-counsel is representing the state. With your permission, can I take up the time? Can I be excused to argue without the mic?
Yes, yes.
There is a mic.
Lawyer should be audible and should be understood without the aid of props. So we appreciate.
Lordship, at the outset, I would like to take their lordship through what is the matter at hand. Please, there are 2 matters which this court is hearing today. It's a division bench, and both the matters, one in appellate capacity and one in its original jurisdiction capacity. The original jurisdiction capacity emerges from out of para 10 of the Moot proposition. Please note para 10. Moot proposition, if their lords are with me.
Yes.
Para 10 read in light with para 18. Above para 18, there is one small Roman letter, point number 5. That is the original matter before this honorable court, which this court has, wherein this court has to determine the damages in the civil suit, which I, as Mr. A, is eligible for. This is the original matter, wherein I am the plaintiff. And then the appellate matter concerns emerges from out of the reading of para number 10, read with para number 11, if their lordships have the same. Now, an interlocutory application, ex parte, was passed in my favor, and that was, they are challenging that also before this court. This is the first appeal. The second is a petition. Please refer to para 16, read with para 17. The petition was filed before this honorable court under Article 226, which was also dismissed. These 2 appellate matter and original matter, one original matter. Now, I will be advancing the argument on the matter. I will be justifying that the ex parte injunction was rightly granted. Now, the proposition is silent as to the dates and the procedure. But there is a maxim which is solely applicable in our case, it goes in our favor. Omni prosementor right esse acta. Find its mentioned in section 119, former 114 of Indian Evidence Act and 119 of BSA. Illustration A. Court may presume common course of conduct and read in light of section 16 of the Indian Evidence Act. I may submit for your perusal that in the absence of any specific mention, this court will presume that all the court activities were happened regularly. Presumption as to regularity in the official acts.
It is rebuttable.
Lordship, I am presenting before, because the fact is silent, I am relying upon a principle, maxim, supported in light of the provisions wherein it has been entrenched to put forth my case, which I will be
What are the
arguing.
prerequisites for drawing a presumption? Presumption dispenses with proof.
Yes, yes.
What are the prerequisites?
It should be allowed. There is a difference between assumption and presumption. Assumption is when we are assuming on our own. Presumption is when the statute allows.
So what are the prerequisites for establishing the presumption that the court should now draw the presumption?
Lordship, I have to establish a fundamental foundation.
Yes.
That time the prop is silent. I will establish. Please refer to para number 10 of the proposition.
One thing more, you are responding to what the petitioners have
Yes,
argued,
yes, yes.
right? So have they anywhere disputed that fact existence?
Lordship, I am interpreting the facts in my favor. If you will follow my argument, if by the time I complete. Now, Lordship, please refer. I'm challenging their appeal. They have appealed the interlocutory injunction. I am calling it premature because the 30-day period they should have waited, because an ex parte injunction has to be converted into an interim injunction by virtue of Rule 3A. That is conversion, or we could call it confirmation state. Please refer to Rule 3A, Order 39, Rule 3A. I may submit for your perusal.
No, you read aloud. We need no. We don't need the book. You just read the provision. We know that.
Certainly, Lordship. The long and short of it is, court has to dispose the application for injunction within 30 days. Now, did they wait for that to happen? Because the proposition is silent on fact. That is why I am calling it.
Whether you objected,
Lordship,
unless you file objection, how it can be decided? Your objection is there.
follow his Lordship.
If an ex parte injunction is granted,
Yes, Lordship.
you are given opportunity to file an objection.
Yes, certainly.
You filed.
My argument is,
Thank you.
I am calling it is a premature appeal.
Yes.
They didn't wait for the they didn't give an opportunity to the single bench to pass the order within disposing of it in 30 days.
There is a provision for 30 days?
Yes, 3A. Order
CPC.
39, Rule 3A.
Replace it.
Order 39, Rule 3A CPC. I may submit.
CPC.
That's why I'm submitting for your perusal.
Sorry.
Yes.
Sorry, but you may be technically, you may have an issue, but so far as the
Practically.
proposition exists,
Certainly.
it exists and there is no opposition there to the proposition made. In the context of the limited issues that we have to allow you time to discuss,
Yes.
this is outside, not treating it as a.
Oh, certainly. I will go
So
ahead.
let us not create a ghost and then try to
Sure.
exercise.
Because Lordship, we for
So
advance that
we can
argument.
assume for the moment we'll assume that it is not, it's beyond 30 days.
Sure.
Let's assume that.
Now, Lordship, I submit for your perusal. No,
Just wait,
Lordship.
just wait. Yes.
So this thing, section order 39(3)(a),
Yes, Lordship.
which you have placed.
Yes, Lordship.
So that is, in your understanding, a mandatory provision.
Yes, Lordship. I am submitting a case
Yes,
law
CD.
for your perusal.
Yes, kindly see. Make an endeavor. Shall make an endeavor.
Yes, Lordship.
You think these words connote an imperative command of the legislature?
Lordship, these are, I am submitting a recent case of 2025, which calls the provisos, both the provisos, mandatory. I have submitted, I have highlighted as well. Because these are legislative humps in the way of interim injunction. I have submitted for your perusal. However, Lordship, leaving that argument aside, I will also argue on merits of the matter. Now, Lordship,
To
I
reply
rely-
to what they have argued.
Certainly.
Yes.
They argued that no reasons are assigned for an ex parte injunction, then it is liable to be dismissed. I am submitting the High Court of Allahabad Association last year's case, 2024, wherein automatic vacation of stay. In that, please note, I have submitted for your perusal. There it has been clearly mentioned, there need not be a detailed recording of reasons. All it has to show is application of the mind. Now, I will establish in the prop, with the help of the prop, that there has been application of mind.
Sir,
Please refer
counsel,
to,
since we are all dealing with, you do not generally mark and write as you pass on a
my
document.
humble apologies, Lordship. I just wanted to highlight. Next time I will take this into account. Lordships,
In
the
the real
argument,
world, certainly.
Which is this judgment?
High Court, first cover page is behind.
What is the citation?
This is the court copy. This is the court, I am submitting the court copy itself. Now, Lordship,
Who was the author of the judgment
author of the judgment,
before the High Court?
High Court, I think one of you must have been there.
No. How can you say I think? Yes. Continue.
Now, Lordships, my argument is, please refer to now para number 11 of the Moot Pro. All I need to show is application of the mind, not detailed recording of reasons as argued by them. Para number 11 says that it granted because there was a irreparable harm. Now, I will also establish the three tests goes in my favor. Irreparable harm, the simple test is it should be beyond repair by financial means. And reputation is something which is beyond repair by financial means. So the High Court, when it passed the ex parte interim injunction, it applied the mind, and that becomes obvious and right in line with section 11. As per the law, 2024 judgment as it stands today, detailed recording of the reasons is not necessary. Mere application of mind is necessary. Now, if I may be allowed to proceed further, Lordship.
Yes.
Now, Lordship, what is the scope of appeal? Whether this court has a certain constriction on it when dealing with matters of injunction. On that also I am submitting a recent case.
You read it.
Ramakan Ambalal Chomsi versus, if I may, because the test is of perversity. Besides other three tests, the ultimate test is of perversity. Lordships.
Yes.
And when is something said to be perverse? The court says that if the lower court could reach a conclusion, merely there is a possibility, the word used is possibility to reach a conclusion, then the High Court will not, and now you have to read it in light of the another flag, which I have flagged, then it cannot substitute its discretion vis-a-vis that of the lower court. So my argument is this appeal is limited. So there was a possibility that the court could have reached a conclusion which it reached. There it stops. The scope of appeal ends there. To tone down my submission with all humility, I would say that
Don't
arguing
just
on the powers of this court, I am just arguing that the scope of appeal ends there. So if I am satisfied their lords on this point,
But is there a lower court?
no, it's
It's an intra-court appeal.
an intra-court appeal. It's a single judge bench of this court. So my argument is that it's a LPA lordship. Sorry, it's a letter patents appeal. Clause 15, we have also submitted jurisdiction. Clause 15 of, we are presuming it to be a Bombay High Court. The reason is in the proposition, para number 5.
You'll call the learned single judge the lower court.
My humble apologies, it was a slip of tongue. Please,
Please proceed.
Now, lordships, this is my primary submission.
Yes.
If I have satisfied their lordships on that.
Please proceed.
Now, I will apply the three tests: the prima facie test, irreparable injury, and as well as balance of convenience test. The prima facie test requires simple. The test evolved through number of cases. I may submit, but I will say it for your lord's permission. Dalpat's case and Morgan Stanley and all of them. Test is likelihood of success in the ultimate final at the time of final
Have
adjudication.
you not submitted compilation earlier?
No, lordship, we are intermittent submissions. These are. We prepared it, but we preferred to rather than drawing your attention to the compendium at the time.
Isn't that taking the other side by surprise?
No, lordships, these judgments are in our memorial already. It is already there mentioned in the memorial.
What about the other side? Whether they have gone through the judgments which you are placing?
Lordship, they have gone through them. In the memorial, we have included the judgment. So it is their duty to
Very
go through. Now, lordship, I'm sorry. So, prima facie case, the test is likelihood of success. It must tilt in our favor, in their favor. In this case, it is not so because they admitted, as well as para 7 of the Moot crop says, it doesn't use the word alleged deepfake. It uses the word deepfake. It is not preceded by the word alleged. So it is a deepfake. So the moment it becomes a deepfake, the prima facie case tilts in our favor. That is my humble submission, lordship. And the second, applying the balance of convenience test, grant versus non-grant, which causes the ultimate prejudice. The court granted it. Has there been any prejudice that is caused to them? None at all whatsoever. In fact, at all, it benefits us and it is only justice done. The last test, irreparable injury. Irreparable injury, in number of judgments it has been said that an injury becomes irreparable when it is beyond repair by financial means. You cannot compensate it. And reputation, they have distinguished property, loss of animals, all these are repairable by virtue of financial means. But reputation of a person is irreparable. So all the three tests stands fulfilled.
What is the right to reputation?
Right to reputation.
Under what statute are you getting the right to
I agree with their lordship, but in Subramaniam Swamy versus Union of India, it was said it is a fundamental right under Article 21. Lordship, now if I may allow to further. Now, Bonnard principle will not apply here because for the simple reason that the truth is true. It is a deep fake. So they cannot take defense of the Bonnard principle. So that is
the Bonnard principle?
Bonnard principle essentially deals with granting of injunction, particularly in the matters of defamation. What is the law? The law is the moment you can take truth of the matter, libel or slander, whatsoever it may be, the moment you can take truth of the matter as a defense, the injunction stands dispelled. But here, truth is unquestionable. They have also admitted that it is deepfake. So does para 7 say it is a deepfake. So the truth of the matter as to whether it being a deepfake or not, that is not under doubt. So as such, the Bonnard principle should also be dispelled.
The deepfake issue is being investigated by the police.
Lordship, but he admitted. He just admitted. If you note, you also asked him the question. Are you agreeing that it is a deepfake? He agreed it's a deepfake. It's an admission to which I am holding them to by virtue of estoppel. Now, if I have satisfied the lordships on the first issue,
Yes.
now that I am arguing upon the second matter, which is the constitutionality matter, 20 clause 3 violation and 21 violation. At the outset, here also there is a maintainability challenge. However, I will not go as far as to challenge the power of this court. But however, I just have to bring to the notice of this court that the matter, the question of law with which their lordships are faced with today, is also sub judice before the Supreme Court of this nation. In Ram Ramasamy versus Foundation of Media Professionals, I am submitting both the judgments. Both the
So if a judgment, if an issue is sub judice before the Supreme Court,
it's a PIL, sir. It's a PIL, and also whatever.
You have not heard the query.
The matter has been listed, lordship.
Just wait.
Oh,
You
sorry.
have not heard the query.
so if a matter is posted before the Supreme Court,
Yes, lordship.
the High Court is divested of its constitutional powers.
No. That is why I said I will tone down my submissions. I cannot go to that extent to say so. However, this court usually, I am relying upon the customary practice, is that let the Supreme Court decide the matter, then
Which
we will hear it.
customary practice?
The
Which
custom,
customary practice? And where it has been recognized or
There is
noticed?
no bar.
lordship, there is no bar, but usually I've read 2 to 3 judgments wherein such an approach is adopted. Let's wait until the Supreme Court says
Which?
the law. on that.
You are getting anyway. Please.
I am
move on.
attempting
Please
my
move on.
best
Please
to
move
put
on.
up-
No, please move on.
Now, lordship, these matters are sub judice, exact same question of law. I will call it compelled de-encryption matter because they are compelling a de-encryption of the phone. Now, I will argue upon what is the law in India as it stands. Where does the problem arise? Now, they relied upon a foreign judgment, Riley versus Supreme Court, US Supreme Court judgment. One question that has to be asked is whether in the US provision, warrantless searches, they dealt with especially warrantless searches of a phone. For what offense? What offense the phone was searched? Whether it was a cognizable, bailable, what is it? Such sort of a distinction has to be seen. Only then you can see the applicability of the judgment in India. Now, the Indian law favors me. There are 2 High Court judgments which will have persuasive value before this Honorable Court. The Virendra Khanna judgment of Karnataka High Court and P. Gopalji judgment of Kerala High Court. Both of which relied upon the ultimate judgment, the founding judgment of Katikalu Ogad, and said that first their lordships may go through the same. This is the Virendra Khanna judgment, submitting for you. The Karnataka High Court has issued some interim guidelines, but said that yes, you have to give the password. It will not be hit by the mandate of 20 clause 3. This is the Karnataka High Court succinctly held this.
So the Karnataka High Court was not following the tradition, as you say, that the matter is sub judice and therefore.
Lordship, back then when it passed the judgment, I think it was not sub judice. Later the matter became sub judice. If I may be allowed to
Yes,
proceed.
please.
Now, Lordship, what then is the issue? Lordship, where does this jurisprudence, what provision did Karnataka High Court rely upon? Katikalu Ogar, para number 13, if you may note. I have submitted for your perusal already. Katikalu Ogar judgment. Para number 13.
What does it say?
So, Lordship, para 13 excludes these matters.
Yes.
Do you have the same? 13, you will note that they say what it means to be a witness and then say that furnishing evidence does not apply, extend to fingerprint grant, thumb impression and all this. Now, Lordship, if I may have your attention here. Mobiles can be unlocked using two methods. One is by virtue of biometric. You can take my fingerprint, and Katikalu Ogat covers that scenario, saying that the moment fingerprints are taken, they will not be hit by 20 clause 3. They are an exception. To opening of a mobile phone using fingerprint is an exception. It will not be self-incrimination. The proposition is silent as to how was the password asked. We are saying that if it is a fingerprint, there cannot be two laws. Then it will be hit by classificatory arbitrariness and Article 14 comes into play. If mobiles can be unlocked using fingerprint, then so should be. It be unlocked using manual means, inputting of the password. So that is the submission I am making, Lordship. That should be the law, I am arguing.
So there is another law, the narco test. The well-recognized principle in our jurisprudence has been
Yes, Lordship.
that you cannot compel somebody to do a narco, undergo a narco because he will speak the truth then.
Yes, Lordship.
That's the rationale.
Yes, Lordship.
So why should that not be applied to you or this case as well? Why should we allow the password to be shared? It's your job to investigate. That is one piece of evidence.
Yes, Lordship. If I got my Lordship's questions right,
So like in a regular criminal case,
yes, Lordship.
confessional statement may be, generally speaking, the best evidence.
Yes, Lordship.
The criminal alone knows what he has done.
Yes, Lordship.
But we look down upon it.
Yes, Lordship.
So that principle of 20 is extended even to that point of statutory recognition. That confessional statements, no.
Lordship, I am representing the state.
Yes?
Now-
That is why we are questioning you. For
Yes,
this.
certainly, Lordship. Now we have a right to investigate, the statutory right to investigate. Now, if I may take you through certain provisions in the BNSS and BSA, there are sufficient safeguards in place. Last, I was going to apply the proportionality test. Therein, I would have covered His Lordship's question in that. There are sufficient safeguards. An admission made to a police officer, if it becomes a confession, is inadmissible per se. One exception is 27. Now, currently, it is 23 proviso. Now, treating whatsoever has been found on the mobile phone as a statement made
Even in 27, no part of the statement inculpatory
certain
statement.
only the
It's only the discovery.
yes, certainly.
So if he says that I have
Yes, Lordship.
sent deep fake from this instrument, only that much, that recovery of that instrument would be relevant.
I
Would be
agree
a
with
relevant
you.
fact.
Yes, Lordship.
There should be a disclosure statement.
Yes, there should be a place from which the discovery is made. However, may I draw your Lordship's attention to para number 7 of the Moot proposition. Sorry, my humble apologies. Para number 14. Read with para number 15. Per se, during investigation process, the police also confiscated phones. The existing legal regime allows the police officer to confiscate phones. Now, there are two regimes. One is warrantless and warrantful. That if I may be allowed to call that. There is one warrantless provision. Proposition is silent. 165 CRPC, currently 185 BNSS. I may submit. Police officer had a reason. All he needs is the reason to believe that some incriminating substance can be found. He can issue a warrant. Even without a warrant, he can confiscate the phone. And it is silent as to whether they were compelled.
Confiscate or seize?
Seize. But the prop employs the word confiscate. The legal word is seize. Now, if I may draw your attention to the fact that the prop is silent as to whether it was a compulsion or not. I may submit for your perusal the Nandini Satpathy case, which they relied upon. I have already submitted. If you just have to, their lordship just have to cull that out. I flagged it as well. The Nandini Satpathy case clearly says mere asking of a passport, mere asking is not compulsion. I have written it. My humble apologies again. Mere asking is not compulsion. For 20 clause 3 to apply,
Where is which paragraph?
I have highlighted, Lordships.
Oh, highlighted, but tell us the paragraph.
Paragraph, my memory is failing me, but that's why I highlighted it on the flag.
Yes. Please continue.
Lordship, for 20 clause 3 to apply, first he must be accused. And 161 extends the same to witnesses as well. I agree there. 2 must be compulsion. It is at this juncture that we are differing. We are calling it's not a compulsion. We just ask for the password. And now, Lordships, the third is incriminating. There could be a scenario. My humble submission is, suppose somebody's phone is confiscated. There are 3 types of things that could be recovered. One is the incriminating circumstance relevant to the fact at hand, issue at hand. Incriminating him for some other potential incrimination for some other offense, and some personal data which is of no use for the purposes of criminal law to apply. Right now, the law as it stands today, it is. I agree that there is some certain insufficiency as to how scrutiny of the electronic devices has to take place. We have CRPC provides and BNSS as well provides for production, seizure, and search, but the scrutiny part is absent, and that is why obviously I just brought to your notice that matter is sub judice, wherein the court is already taking this into consideration. Now, my last argument is, since you rely upon the US principle, let's rely it upon what is the practice there. US jurisprudence has been successful because ultimately this is a matter wherein this court has to balance between 2 rights.
See, how is the US, first of all, you have to establish how US jurisprudence is applicable at all in the light of if we can come to a conclusion independently in the light of the statutory provisions and the constitutional provisions.
Yes,
First
Lordship.
of all, you have to establish that they are
Certainly.
pari-materia.
Certainly, Lordship. I'll establish how it is pari-materia. For Fifth Amendment, their Fifth Amendment grants them the right to self-incrimination. Simply put, 20 clause 3 grants us the same right. However, the jurisprudence on the same is also same. Why do I say that? If you read Selvi's judgment, Lordships, I may give you for your perusal. Selvi relied upon a US jurisprudence case, Hoffman's case, to develop the jurisprudence it developed. And now currently the jurisprudence, I will take their Lordships, I'll complete my argument later, their Lordships will be able to appreciate my submissions. If you may know, the second part, not this one, Lordship, the other submission, yes. This one, Lordship.
This one.
Yes. US, because Lordship, this ultimately we need to look what this issue is about. Balancing the statutory right of the police to investigate vis-a-vis the right to privacy. There are 2 rights, and usually the test which is applied is the test of proportionality. And the US courts have come with a means called foregone conclusion doctrine. Simply put, Davis case and all that, they say it could be very well borrowed. I will say how. It is very much rational and it is establishing the balance which this court has to ultimately establish. US court says, foregone conclusion doctrine says, if the investigating authority is already aware of the specific material, particularity element on your mobile, on your device, then it will not be hit by self-incrimination. That is the doctrine because it is a foregone conclusion. Here what we are doing is merely getting what we already know. So that is not hit by 20 clause 3. Some sort of a principle could be evolved there. We are open, as state, we are open to the guidelines.
There is a limitation. How do you think this foregone conclusion, if that is to be used, the police can come to any foregone conclusion?
That is where
and then
Lordship,
take out any other document. They'll nullify Article 20.
but that is where Lordship warrants and all this proof. Even the procedure is, even if a police without issuing a warrant or does any act, he is answerable to the magistrate. Or such sort of accountability procedure could be put in place. It is a suggestion which we are willing to make. Furthermore, Lordships, in India we do not follow something called the fruit of poisonous tree. It least matters R.M. Malkani's case and Puranmal's case, the landmark judgment, their Lordship very well remember, that even evidence procured by illegal means, if it is evidence, it is admissible. So these are principles which aid me. And as such...
But there is already an exception in Puranmal.
Yes, I agree, Lordship. But this is a case wherein we are trying to make it fall. I have a big case. I am attempting my best to argue, Lordship, because I am defending the state. If I have satisfied their Lordships there, now I will apply the proportionality test and end my argument. The proportionality test comes with 4 prongs. Their Lordships are very well aware. The legitimate aim state, then the necessity stage, balancing stage, and ultimately one was added by subsequent judgment of Anuradha Basin. It said that there should be a procedural safeguard, should put in place procedural safeguard. Now, I will be applying, the Lordship may disagree if I am, applying it in a manner which just favors us.
No, you need not be decided so soon.
Yes.
Certainly,
Course of
Lordships.
arguments.
I was expecting this.
Yes.
Lordships, first is legitimate aim stage. Right to investigate and get to the roots of the crime is a legitimate object of the state. That this passes muster. The first stage passes muster. The second stage is the necessity stage, which essentially calls upon us to adopt the least invasive possibility. Now, here, Lordships, the crime at hand involves digital device. Could we have come up with any least invasive possibility? Also, given the fact that the existing the legal regime doesn't have anything of that sort. So the act has to be judged in light of what is the current legal regime. And the necessity stage also passes muster. The third is the balancing stage. The right to investigate vis-a-vis the right to privacy. I already put forth a possibility of foregone conclusion doctrine, which could be taken into account. And the last stage is imposing of procedural safeguards. Procedural safeguards, I already told, Evidence Act and BNSS have enough of them. However, if we are to issue additional, particularly applicable to digital devices, then this court may very well issue. The state has no objection. Having thus argued before this court, I rest my case unless their lordships have no questions for me.
Thank you.
It was a pleasure arguing before this honorable bench.
Yes, please.
Much obliged, Lordships. Lordships, the Council is representing the state in both the matters, issue number 2 and 4, as mentioned in our proposed Moot memorial, the red one. Now, the issue that I am dealing with has to be read in the light of a maxim. Quando lex aliquid concedit, consider Rebuttal et it sin quo res ispa esse non potest. It's a rather long maxim. However, it translates to, if the law gives man something, it also gives it with what it cannot exist. Meaning that since we have been called before this honorable court in the light of exercise of their power under section 482 of CRPC and 528 of BNSS, Lordships very well have the power to allow for the investigation to continue and reject the plea of quashing of investigation against the accused appellants in this manner. Now, Lordships, the issue at hand, issue number 2, the dictum of which reads as under whether the criminal proceedings are liable to be quashed by virtue of section 528 on 2 grounds. Firstly, mere reception and not circulation, and secondly, that there is no nexus between what the appellants contend, the defamatory video, as well as the digital arrest. These are the 2 grounds with which the appellants have approached this honorable court to quash the criminal proceedings. Now, what I'd be arguing is that there is indeed a proximate cause, there is a nexus between the defamatory video that the techies group themselves circulated, as mentioned in paragraph number 5, as well as paragraph number 6, and what happened in paragraph number 8, the loss of 75 lakhs from account of Mr. A, the customs officer. These all incidents are corrected. That is why this forms a ground for which criminal proceedings cannot be quashed. Secondly, the techies group, which contend that they were mere reception, they only received the defamatory video and further not circulated. That also stands quashed in the light of the judgment that I will be producing. However, the dictum of the judgment was that if there is an overwhelming element of criminality in defamatory video and circulation of such, this honorable court should at least not scuffle the investigation at a very primary stage. The investigation in this case is at a very primary stage, and the appellants have approached this court to quash that very investigation. Therefore, in order to address my issue in totality, I would seek honorable benches. Much obliged. Lordships, the second issue, to address the second issue, I have formulated 3 lines of submissions. First is the scrutiny, the lens through which the quashing should be adjudicated. For that, I submit the cases of Pradeep Kumar Kesarwani versus State of Uttar Pradesh as well as Rajiv Thapar versus Madan Lal Kapoor. Now, Lordship, Pradeep Kumar Kesarwani is a rather early judgment, recent judgment of 2025, which states 4 steps through which the veracity of plea of quashing has to be understood. There are 4 steps. It was further incorporated through the dictum of Rajiv Thapar case of 2013. Lordships, the flagged aspect, if I may direct Lordships on page number 13 of Pradeep Kesarwani judgment, paragraph number 20, and Rajiv Thapar case, page number 13, paragraph number 23. Now, there are 4 steps through which this Honorable Court needs to see whether or not the quashing plea needs to be adjudicated. The first is Sterling material test. Lordships, Honorable, if your Lordships are with me. If your Lordships are with me now. There are 4 steps that were evolved in these cases. The first step was Sterling material quality test. Lordships, appellant have not introduced any Sterling material which refutes.
They are not relying on that principle. They are relying on the second aspect.
Second aspect. Lordship, now if your Lordships may note, all these 4 principles, all these 4 steps need to be affirmative on the part of the appellants for the proceedings to be quashed. Now, none of these steps are affirmative, or at least one is defective.
Besides the allegation that such a deep fake has been created and circulated, what independent material has the state agency gathered in support of that allegation?
Lordships, we want to investigate. However, the appellants have come before this.
Therefore, what other thing have you investigated? What other evidence have you gathered?
Lordships, since the prop is silent, however, Lordships, we have circulated it back to the Techies group itself, CD Enterprises, the admins of which are also the admins of Techies group. Lordships, further, it needs to be noted that this would be further dealt by me, if your Lordships are with me.
Yes, yes.
If your Lordships, this would be further dealt by me by addressing the proximate cause. Lordships, you may note on paragraph number 7 and 8, the circulation happened on 19th July, and on the same day, later that day, this digital arrest happened. And both originate from the same point, that is Techies Group, which is a division of CD Enterprises. Mr. G, Miss G, Miss F, and Mr. E are partners in that CD Enterprises, if your Lordships are with me. Much obliged, Lordships. Now, Lordships, on account of failing all these steps, the plea of quashing criminal investigation itself is vitiated at this very junction. Now, further, whether or not there is prima facie proximate cause, Lordships, as advanced earlier, there is indeed a prima facie proximate cause. The origination took place from Techies Group. The circulators were Techies Group. And Lordships, if we were allowed to investigate the matter further, we would find out a sterling material to further incriminate the accused, in at least help in the investigation. Now, Lordships, whether or not the act that the accused have committed, the admins of which can be held vicariously criminally liable. Lordships, for that, I have a case.
What is your concept of sterling and material of sterling and impeccable quality? It is
Lordships,
under, kindly consider that this is a jurisdiction under 482, erstwhile 482. So, while making a finding in that jurisdiction as to whether the material is of a sterling and an impeccable quality, you think the court has to sift the evidence or call for the evidence and first determine whether it is of sterling and impeccable quality?
Lordships, ideally the position of law states that whoever approaches the court needs to provide a sterling material for the investigation.
How will you determine the character, impeccability of the material? It has to be done only after, is it required to be done only after you've taken the entire evidence?
Indeed, Lordship. And To understand it, I would be advancing arguments on twofold. Firstly, Lordships, I need to develop the background. Lordships, it is the appellant that wants the criminal investigation to be quashed. So they need to produce evidence of sterling nature
The
for
burden is on them. That is
in the Lordship. Now, what we are arguing is, in the light of Vesa Holdings versus State of Kerala, Lordships, the Honorable Supreme Court, by the virtue of 3-judge bench of Honorable Supreme Court, the High Court has been cast upon a duty to investigate in the matters that is to the evidence that appellants have raised before this Honorable
Which
Court.
case?
Lordships, Vesa Holding, a copy is also here, Lordships. The council seeks a moment of indulgence, Lordships.
Okay, that's all right. You continue. We'll see that later.
Lordships, further, it has further been developed in Niharika Infrastructure versus State of Maharashtra. A case copy is also submitted. Lordships, if you turn to the next page, the first few lines mention the exact same thing. It is the
What
duty
does
of the
it
High
say?
Court.
What does it say?
Lordship, it says that although the police in 13.2 have the statutory right to investigate, 13.6 states that the court should not quash any criminal investigation to stifle at a very early stage, to stifle the criminal proceedings at a very early stage. Further, whether or not the court has appreciated the material produced before it by the appellants, it cannot delve into quashing. It has to be exercised in rarest of the rare cases, as also developed in Bhajan Lal case, State of Haryana versus Bhajan Lal case, 1990 case, reported in 1992. Lordships, if you are with me. Much observed, Lordships. Lordships, having established that there indeed lies a proximate cause between the circulation of defamatory video as well as the, the defamation suit that has been instituted against the appellants. Lordships, now I'd be advancing arguments how mere reception in this case also attracts criminal liability. Lordships, one of the grounds that the appellant have is mere reception does not attract criminal liability. Lordships, now for that matter, we have impleaded.
Mere reception.
Lordships, there were some members of Techies group, as mentioned in the proposition as well, Lordships, paragraph number 11,
Who are not responsible for circulation.
who did not circulate it as such.
Not
Now,
yet.
this is also one of the grounds of raising this appeal, Lordship, writ appeal that is present before this full bench. Now, Lordships, it was a passive reception. They were not circulating it as such. However, in this present case, there is a chance that such a video of a public servant being circulated can indeed hamper the public order under Article 19.2. Therefore, it causes this state, police, to investigate into this matter. This becomes statutory right of investigating agencies to investigate into the matter. Therefore, in this context, mere reception can also attract criminal liability. Therefore, any plea with respect to the quashing of FIR or quashing of criminal proceedings that this Honorable Court has been approached with by the appellants is vitiated.
You are saying that even receipt of messages incriminates them. Receiving messages from others is an act of incrimination.
Lordships, we have implemented.
Are you suggesting that mere receipt of messages is sufficient to incriminate?
Lordships, we are attracting this to the administrator, Mr. E, Ms. F, and Ms. G, who are the owners of CD Enterprises, the social media marketing platform.
No, what about the other passive
Lordships,
reception of
the
passive?
defamatory suit is already ongoing. Now, what we are investigating is the criminal part, the digital arrest part.
That's right. The point is that those persons who have received, the evidence against them is merely receipt of the offending messages, not circulation. So you think mere receiving of messages
No, Your Lordship.
constitutes an offence?
No, Your Lordship.
Is
It
that
does
your
not.
suggestion?
Lordships, although circulation is an offence under 67 of IT Act, mere reception is not. However, the admins which we have implicated as party, Mr. E, Ms. F, and Ms. G, are not only mere receptionists. They are admins, administrators, they are owners of CD Enterprises.
No, but how do they know what other member is going to?
Lordship, precisely. This is why we have initiated an investigation. Lordship, for the reason that we have the reason that we have initiated an FIR against them is because the principles of criminal vicarious liability asks us to at least implead the directors of a company if there is an allegation or an investigation that is needed to be made. This is why.
So you are equating an administrator of a group with the director of a company.
Lordship, administrator of the group, Lordship, they are the owners of a company. Lordship, Mr. E, as mentioned in paragraph number 9 and 10 as well. Lordship, they are owners. They are the partnership. They are partners in this social media partnership firm. Mr. E, Ms. F, and Ms. G, if I may have you on the same page. We are implicating them, Lordship. They are also liable. The three partners are also liable, and therefore we also want a criminal investigation to proceed against them. Lordship, para 14 as well.
So what are the elements which will implicate the owner of a company? To what extent? What do you have to establish before you can say that this director of a company becomes liable for, becomes criminally liable?
Lordships, for that, the FIR has been instituted under Section 61 conspiracy as well. Therefore, by the virtue of conspiracy charges, they are also made liable. And further, Lordships, it all happened under their wing, and this is one of our pleas, that at least the investigation should be continued. This is a grave matter that is present before this Honorable Court, and quashing of investigation at such a preliminary stage should not be allowed. That is what our plea is, if your Lordships are with me. Much obliged, Lordships. Lordships, now I'd be advancing arguments on the fourth issue. The fourth issue, the dictum of which reads as under whether whether a criminal investigation is liable to be halted on the ground that a civil suit to the same matter is sub judice. Now, Lordships, at the very outset, I'd like to submit this case that the appellants relied on. The MS Sheriff case. It's a five-judge constitutional bench judgment of 1954, authored by Justice Vivian Bose, former Justice Vivian Bose. Lordships, in that case, now appellants, they relied on it partly. In that case as well, Justice Vivian Bose was of the opinion that criminal proceedings should take precedence over civil proceedings, that I have highlighted on the second last page, Lordships. Therefore, any allegation or any plea with respect to whether or not civil or criminal matters should be quashed if civil matter is already sub judice, it stands vitiated. Now, Lordships, I'd be advancing arguments on the merits of this issue, if I'm allowed.
Yes, yes.
Much obliged, Lordships. Lordships, for that I have prepared 4 lines of submission. Firstly, that the legal principle allows that arising from the same set of facts, there can be 2 different kind of remedies which are available to the defendants in this case, respondents in this case. For that, I have relied on 2 judgments. Firstly, Katyani versus Siddharth, July judgment of 2025. Lordship, the flag aspect. The only real test that this Honorable Court needs to delve into is the test of criminality. Lordships, all the charges that the accused have been leveled up against are of cognizable nature. Therefore, element of criminality is ipso facto present. The allegations that have been charged against the accused in this matter includes 336, 318 and 61 as well as 127 of BNSS. All of these are cognizable offences. Lordships, even if we see it in threshold of State of Haryana versus Bhajan Lal judgment, paragraph number 2, the second direction that the State of Haryana versus Bhajan Lal said, that it cannot be quashed if a cognizable offence is made out. The appellants in this case have argued that there is no prima facie case that is made out against them. However, your Lordships, FIR make it very clear that these are all cognizable offences as well. They do not even require the statutory right of police to investigate into it. Lordships, that is one of the submissions that is there. Lordships, further to bolster the submission that both of these proceedings, civil as well as criminal proceedings, are indeed harmonious in nature, I have the judgment of Pratibha Rani versus Suraj Kumar, 1985 judgment.
What is the meaning of harmonious in nature?
Lordships, that they can exist coextensively and they are not mutually exclusive to each other. Precisely the dictum in this judgment, Lordship. If there is a matter primarily disguised as a civil or criminal matter, and there is same matter gives way to either criminal or civil remedies, both can exist. Lordship, this is what the dictum of Pratibha Rani said. Submitted for perusal of this honorable bench. Lordships, further Lordships, S.N. Vijay Lakshmi recent judgment also upholds this. And lastly, reported in October, Supreme Court judge bench, Indrajit Singh versus State of Uttar Pradesh, is also extends the same principle, that so long as there are two different remedies available from arising from the same set of action, two different kind of proceedings can still sustain. Lordships, further, it is to be noted that the appellants have approached this court under the guise of only defamation suit. This is what they allege. However, there are two different matters that are being pursued here. First is with respect to the defamation case, and second is respect to the digital arrest, cyber fraud that happened. Lordships, if civil suit is for damages, it is of compensatory nature. The digital arrest is of punitive nature. The damages that it attracts are of punitive nature. And to bolster that submission, Lordships, I'd be submitting the case of Iqbal Singh. Lordships, as the Honorable Bench already mentioned, there are two different set of proofs. The flagged aspect. Lordships, if you may have the submission. Page number 21, paragraph number 32. Lordships. Now, it says that there are double standards of proof. Civil cases require preponderance of probabilities, and this Honorable Court needs to adjudicate this matter in the light of burden of proof principle as well. Therefore, these two different matters, one of digital arrest, of which FIR has been lodged against appellants, and another is defamatory suit, which again is instituted against them. Lordship, these are two distinct matters for which two distinct remedies are available. Although these matters arise from a similar set of facts, however, the relief that we are aiming are of two distinct nature. This is why one of our plea is that since these are two different remedies, the quashing of FIR or stay of investigation under the light of sub judice matter cannot be held tenable before this Honorable Court. Lastly, Lordships, I would like to present this argument in the light of third line of submission, which is civil proceedings do not act as a bar to prosecution, especially involving societal harm. Lordships, for that, I have a judgment which expressly states the same thing. Lordship, this involves a societal harm at large. Lordship, under the threat of public harm under Article 19.2, a social media defamatory video being circulated against a public servant. Lordship, if we have a separate remedy available, Lordship, civil suit does not act as a bar to avail for us that remedy as well, criminal remedy as well. Therefore, the principle as it stands of 2025 October is very simple. Unless there is an element of criminality, the real test that is to understand whether or not the case has element of criminality. If the civil proceeding is cloaked is a criminal offence, then we need to look into whether or not the criminal offence also reeks of criminality.
You are saying only criminality is the test.
Lordship,
If on the facts in the facts of a case criminality is disclosed, then criminal prosecution cannot be stayed. That's the only test according to you.
no, Lordships, that is definitely not a test. However, Lordships,
Then what is the test?
Lordships, if I may be granted at least extension of 2 minutes, much obliged. Lordships, the quashing has to be read in light of, again, State of Haryana versus Bhajanlal, in which 7 principles were made out. Lordship, that too acts as a test. Relying on the same principles were these judgments made. And Supreme Court, it condensed it in the form of test of criminality. That is what...
Which judgment was that? Test of criminality?
Lordships, P.S. Katyani, Lordship. Katyani versus P.S. Reddy, Siddharth P.S. Reddy of 2025. Lordship, if we may turn to page number 10, paragraph number 19, and page number 12, paragraph number 23. If you may have it, Lordships.
Don't you think it is the test of prejudice which should prevail?
Lordships?
It is the test of prejudice which should prevail. That is, whether if you continue the civil and criminal proceedings simultaneously, then the defense of the accused in the criminal prosecution would be prejudiced because he'll have to show us that.
Lordships, that again, Lordships, I believe you are alluding to the abuse of process as alleged in different cases. Lordships, abuse of process can only happen if there is lack of prima facie case. What we are contending is these are cognizable offences that have been committed, which impact the society at harm. Therefore, anything that the appellants present needs to be in such a manner which prima facie vitiates their element of criminality. Again, back to the first test, Lordships, sterling material quality test. Lordships, we have instituted against 66C, 66D,
Yes.
61, 127 of BNS, 318 of BNS, which is again is cognizable, and 336, particularly subsection 336, subsection 4, Lordships. Now, these are all punishable for more than 3 years and are cognizable in nature. Therefore, abuse of process in this case cannot be held to be tenable. Lordships, if your Lordships have any further query, I submit to the query of this bench. However, in absence of such, I'd like the permission of this Honourable Court to proceed with the prayer.
Please proceed.
Much obliged, Lordships. Lordships, wherefore, in the light of arguments advanced, issues raised, and authorities cited, the respondents humbly plead before this Honourable Court to dismiss the clubbed appeal that has been presented by the appellants, to dismiss the plea, to set aside the ex parte injunction, to hold that the compelled de-encryption of password is not violative of Article 21 and Article 20 sub plus 3, and hold that all the members, at least all the admins, all the partners, are liable to be investigated. Lastly, to hold that the stay of proceedings in this manner can be sustained. Lordships, we want the investigation to continue. These are the prayers that we advance.
Thank you.
Thank you.
Much obliged.
Brother will dictate the judgment.
It was a pleasure arguing before this honourable bench.
You want to add something?
Rebuttal. Yes.
Yes, yes, please.
Mic is not working.
No, just wait.
Yes.
Firstly, Your Lordships, I would like to highlight the fact that in the respondent's memorial, under the statement of jurisdiction, they have stated clause 15 of the letters patent 1865, but it is restricted to the Bombay High Court. And in this present case, it has only been stated that the laws of India are pari materia in this present case. So it is a mere assumption that this particular clause can be applied in this particular matter because we are before the High Court of Innovate and not High Court of Bombay, Your Lordships. Also, Your Lordships, I would want to clarify on the context of deepfake and alleged deepfake videos. Your Lordships, the appellants have already clarified that earlier when the deepfake videos was circulated, it was not within the knowledge of the appellants that it was a deepfake video. But we have been referring here it as deepfake video because in order to easily communicate the fact that it was a deepfake video. It is not that we are agreeing that it was a deepfake video at that point.
It is not your admission.
Indeed, Your Lordship. Also, Your Lordship, the respondents have highlighted the case of Virendra Khanna, but in their favor, but various judgments in our favor as well of the High Courts as well as the Supreme Court, especially the Sanket Bhadresh Modi case and the Selvi case, and the Selvi case clearly explicitly states that the compulsion of passwords will be violative of Article 20 Clause 3. Your Lordships, also they have mentioned that the Kathi Kalu case, but it was strictly restricted to the physical specimens, and they said that fingerprint was asked for unlocking that particular device, but in the case it was explicitly stated that it was only for identification purposes. Therefore, it won't be applicable in this particular matter. Your Lordship, also it has been clarified in the Moot Court proposition that the police officers confiscated and checked the mobile devices. Thereby implying that there was a compulsion in order to produce or compel those particular passwords. Your Lordships, the foregone conclusion doctrine as highlighted by the respondents. Firstly, it is not recognized in India as such yet, and secondly, the police in this present matter does not know the location of this evidence. This can only be applied when the police knows where the location of the evidence is in a mobile phone. But here in this present matter, if we compel the accused to provide a password, they'll have access to every document present in that particular mobile phone. Also, Your Lordship, the least intrusive methods was not applied in this particular case, and also highlighted by in the case of Selby that even if for the purposes of investigation, privacy can be intruded, but it cannot violate Article 20, Clause 3. And other methods, third party supervision of court, or the consent or the presence of lawyer, these could have been the least intrusive methods rather than just compelling the appellants to provide passwords in this present matter. Also, Your Lordships, the very most important point, Your Lordships, I would want to clarify that there was a particular deepfake video, and then the second issue was that later that day a cyber arrest happened. But Your Lordships, it is clearly specified in the Moot proposition, if Your Lordships may refer. Your Lordships, in para 7 and 8, in para 7, it has been clearly stated that these videos were further forwarded and reposted publicly by some users, not the members, some users, and very soon widely circulated. Your Lordships, it cannot be stated that these members were again the ED officials who posed as ED officials and then caused the cyber arrest. Therefore, there is no link that the accused here in this present matter, who are accused for the circulation of deepfake videos, they cannot be stated again that they are also the ones who have caused that cyber arrest later that day. Because since the video has been widely circulated, there could have been any other person apart from the members of this group who has the knowledge of that particular deepfake video. Those people can still then commit the cyber arrest, but it cannot be said that the members have committed that cyber arrest. Therefore, there is no link in this present matter. Also, Your Lordship, for these particular reasons, no prima facie link exists, and thereby we are requesting for quashing under Section 528 because High Court has inherent powers when no prima facie case exists. Also, one last point, Your Lordships, in this present case, we are referring to passive membership. When we are contending that passive memberships cannot be held liable, we are also including the people who are members of the group but have not seen that particular video. It has been named passive members due to this particular reason, that they might be a member of that group but they might have not seen that particular video. But still they are imposing a liability on us. But even if they have seen it, there is no obligation for them to report it. Thereby all these arguments cannot be stated. Much obliged, Your Lordships. It was an honor presenting before this bench.
Thank you.
Well, just
2 minutes by the clock.
answering her.
2 minutes by the clock.
Outside, I would like to apologize for my constant runs. It's not. I don't mean any offense to this court. A bit emetic. That's why I had to run.
5 seconds gone.
Lordships, I draw your attention. This is an LPA, letter patents appeal. It's not been provided in Constitution. So why did we assume it is a Mumbai High Court? Please refer to para number 6 of the Moot proposition. Innovate is a metropolitan city located in West Tech Asia, along the coastline of Salty Sea, and is also known as financial capital of Tech Asia. Only one ruling out assumption would be Bombay High Court, and intra-court appeal has to be entrenched in one of the provisions. Where else would we have gone for jurisdiction other than that, Lordship?
Calcutta?
Lordships, financial
Chennai.
capital.
It's a
Financial
matter of-
capital.
It's a matter of perception.
Lordship,
Because
ruling
it's-
out possibility.
The country is Tech Asia.
May I proceed, Lordships? Now, Lordship, explicit admission. She said that they are not admitting it is a deep fake. But their first speaker, the second speaker.
Mainly.
Yes, sir. Lordship, there para number 7 clearly says that it is, I already argued that it is not preceded by the word alleged deepfake. It is a deepfake. And Kathikalu Ogad, how do you apply it? Why is there a selective application? Now, Lordship, I also took their Lordship through the scenario. I may take fingerprint. This is what Kathikalu Ogad says. Now, what do I use my fingerprint for? That is for us, for the police authorities to determine. And if we use it to open the phone, and manual fingerprint is hit by 20 clause 3, that would be against Article 14 because it is creating two classes without any intelligible differential. And the last is para 15 employs the word confiscated, and proportionality test I already took their lords through, and nexus between cyber fraud and this, soonness on the same day. Soonness is the factor. Okay. It was a pleasure arguing. I again apologize.
No, it's all right.
All right, so having heard most informed and pleasant arguments, we reserve for marking. And we are happy we don't have to pronounce a judgment. Thank you so much.
प्रतियोगिता का यह अंतिम चरण यहाँ समाप्त होता है। दोनों ही टीमों ने उत्कृष्ट प्रदर्शन दिया, इसके लिए आपको बधाई। प्रतियोगिता का परिणाम सुरक्षित कर लिया गया है। प्रतियोगिता का परिणाम सुरक्षित कर लिया गया है, जिसकी उद्घोषणा पुरस्कार वितरण सत्र में की जाएगी। पुरस्कार वितरण सत्र एवं उपस्थित अतिथिगणों के समुचित सत्कार हेतु यह मंच सुदृढ़ करने के लिए हम 15 मिनट का एक अल्प विराम ले रहे हैं। पुनः इस प्रेक्षागृह में हम सभी पुरस्कार वितरण कार्यक्रम में एकत्रित होंगे। प्रतिभागियों का धन्यवाद एवं शुभकामनाएं।
Now that the final rounds have come to an end, we know the curiosity is at its peak. But please hold on till the results are revealed during the award ceremony. So till then, dil tham ke baithiye, as the moment of glory is just a little while away.
आप सभी से विशेष आग्रह है कि पुरस्कार वितरण सत्र में अपनी गरिमामयी उपस्थिति से हमें पुनः कृतार्थ करेंगे। ऐसी आशा के साथ धन्यवाद।
You can give an encouraging judgment. You cannot be in agreement or but there is no room to confer. You can confer. But what is the pattern? You can each individual that marks on its own. You can collectively give a single mark. Individually mark and it is total. Who will total? So we can.
मधुरं गमनं मधुरं मधुराधिपते रखिलं मधुरम् वचनं मधुरं वलितं मधुरं चलितं मधुरं भ्रमितं मधुरं मधुराधिपते रखिलं मधुरं वेणुर्मधुरो रेणुर्मधुरा पाणिर्मधुरा पादो मधुरा नित्यं मधुरं सन्ध्यं मधुरं मधुराधिपते रखिलं मधुरं अधरं मधुरं वदनं मधुरं नयनं मधुरं हसितं मधुरं हृदयं मधुरं गमनं मधुरं मधुराधिपते रखिलं मधुरम् भुक्तं मधुरं सुप्तं मधुरं रूपं मधुरं तिलकं मधुरं मधुराधिपते रखिलं मधुरम् अधरं मधुरं वदनं मधुरं नयनं मधुरं हसितं मधुरं हृदयं मधुरं गमनं मधुरं मधुराधिपते रखिलं मधुरम् अधरं मधुरं वदनं मधुरं नयनं मधुरं हसितं मधुरं हृदयं मधुरं गमनं मधुरं मधुराधिपते रखिलं मधुरम् अधरं मधुरं वदनं मधुरं नयनं मधुरं हसितं मधुरं हृदयं मधुरं गमनं मधुरं मधुराधिपते रखिलं मधुरम् राधे कृष्णा कृष्ण कृष्णा राधे 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 कृष्ण कृष्णा राधे कृष्ण कृष्णा
मधुराधिपते रखिलम मधुरम मनोमय प्रस्तुति भक्ति व संस्कृति मिश्र। आराध्य को समर्पित व मधुराष्टकम की पंक्तियों को राग मिश्र काफी में स्वर प्रदान करने वाली छात्राएं थीं प्रिंसेस श्रीवास्तव, स्वाति ओझा, प्रेरणा श्रीवास्तव, अनुष्का मिश्रा, दिव्यांशी राजपूत, उमाम परवीन, सृष्टि सोनकर व गौरी श्रीवास्तव। वाद्य यंत्रों के साथ संगत कर रहे थे श्री खोल पर डॉक्टर पार्थ डे, पखावज पर डॉक्टर आशीष कुमार, हारमोनियम पर डॉक्टर बलदीप कौर, ऑक्टोपैड पर श्री दीपक मालवीय व सिंथेसाइजर पर श्री जयजीत मजुमदार। यह सांस्कृतिक कार्यक्रम समस्त महाविद्यालय सांस्कृतिक समिति के सहयोग से संपन्न हुआ है। हम समस्त सांस्कृतिक समिति के प्रति भी आभार व्यक्त करते हैं। इस सांस्कृतिक कार्यक्रम के उपरांत पुरस्कार वितरण में पधारे अतिथियों के समुचित सत्कार एवं कार्यक्रम की आगे की प्रक्रिया को सुचारू रूप से संपन्न कराने के उद्देश्य से मंच को सुगठित करने की आवश्यकता है। आप सभी से सविनम्र अनुरोध है कि धैर्यपूर्ण हमारा सहयोग करें।
I request our principal, Professor Lalima Singh, to kindly take her seat on the stage. Student representative may assist ma'am to the stage.
माननीय न्यायमूर्ति श्री अजय भनोत सर से आग्रहपूर्ण निवेदन है कि आप मंच पर अपना स्थान ग्रहण करें। छात्र परिषद की सदस्य से अपेक्षित सहयोग की आकांक्षा है।
I request Honorable Mr. Justice Siddharth of the Allahabad High Court to kindly take his seat on the stage. Vice President, Student Council may assist sir to the stage.
पुरस्कार वितरण सत्र के मुख्य अतिथि माननीय न्यायमूर्ति श्री सौमित्र दयाल सिंह सर से विनम्र अनुरोध है कि आप मंचस्थ होकर हमें उपकृत करें। छात्र परिषद के सदस्य से आवश्यक सहयोग की आकांक्षा है।
Thank you, everyone. I now request our principal, Professor Lalima Singh, to extend a warm welcome to our eminent guests and dignitaries present here.
A very good afternoon to one and all present here. Honorable guests, distinguished legal luminaries, faculty members, dedicated student volunteers, and of course, the most importantly, the brilliant young advocates who have made a place for themselves in this intellectual arena. I take profound pride and happy to extend a very warm welcome to all of you on the third Justice Gopalji Mehrotra National Moot Court competition. At the very outset, I would like to extend my gratitude to Chandralok and Mahajan, our esteemed collaborators, whose steady support and shared vision has been the cornerstone of this endeavor. We are grateful to you and looking forward for many such endeavors in the coming years. This moot court competition is proving a ground that you are being prepared for a few lawyers who will be doing justice with the nation. The 2-day journey was indeed a firework of intellect. Though I was not in the courtroom, but the report and the feedback which we got from the judge evaluators was very satisfying that indeed a very hard work has been done for this National Moot Court. And it is a testimony that this effort of SS Khanna Girls Degree College is gaining eminence and recognition across the country. We feel proud with your participation, and thank you, dear participants, who all have come from the different parts of the country to make this event a success. We are immensely privileged to have Honorable Justice S.T. Singh, sir. Presence of Mrs. S.T. Singh has doubled our joy. Honorable Mr. Justice Siddharth ji, Honorable Mr. Justice Ajay Bhanot ji, we all are grateful to you for giving your consent to judge the final round of the National Moot Court and also gracing this occasion. It is indeed very inspiring for the young students to have you amidst us on such occasions. Thank you, sir, for being with us. I also welcome the other honorable judges, Justice Arun Kumar, who is also present here. Thank you, sir, for being with us this afternoon. Would like to share with you all that in our steadfast commitment to integrity and impartiality, the college has refrained from competing in this National Moot Court. Dear participants, would like to say, win or lose, that does not matter much. But you have enriched this competition by your participation. Thank you for participating, and I appreciate your courage because I feel participation is more important than the result. Thank you, children. I also extend a warm welcome to the members of the Saraswat Khatri Pathshala Society, my judge evaluators, who took so much of pains to be with us since yesterday. A very warm and cordial welcome to all of you. I also welcome Shri Avi Tandon, Lawyer Supreme Court from New Delhi, and Dr. Adit Sareen from the Johns Hopkins Hospital, US, for being with us this afternoon. Presence of such virtue is a source of motivation, especially for the young students. Once again, a very warm welcome to one and all who are present in this auditorium. Thank you.
धन्यवाद मैम। धन्यवाद मैम। विविध संस्थानों द्वारा आयोजित मूट कोर्ट प्रतियोगिता का उद्देश्य विधिक क्षेत्र में नवप्रवेशी युवाओं के मस्तिष्क के समक्ष नई समस्याओं को उजागर कर समसामयिक विषयों के माध्यम से उनकी तार्किक व विश्लेषणात्मक क्षमता का विकास करना है, ताकि वे न्यायिक प्रक्रिया के लिए पूर्णतः तैयार हो सकें और विधिक व्यवहारिकता के साथ सशक्त हस्ताक्षर के रूप में स्थापित हों। सदनलाल सांवलदास खन्ना महिला महाविद्यालय भी गत 2 वर्षों से इस कार्य को निरंतर परिणति प्रदान कर रहा है। आज हम तृतीय जस्टिस गोपालजी मेहरोत्रा राष्ट्रीय मूट कोर्ट प्रतियोगिता के साक्षी हैं। इस प्रतियोगिता की विशिष्टता अन्य सभी प्रतियोगिताओं के सापेक्ष इसकी मौलिकता एवं समृद्धि को रेखांकित करने के उद्देश्य से हम जस्टिस गोपालजी मेहरोत्रा राष्ट्रीय मूट कोर्ट प्रतियोगिता की कार्यकारिणी समिति के अध्यक्ष श्री माननीय न्यायमूर्ति श्री अरुण टंडन सर से निवेदन करते हैं कि आप सभा के समक्ष आख्या प्रस्तुत करें।
गुड आफ्टरनून एंड नमस्ते। जितने लोग आप आए हैं अच्छा लगता है। शुरू से ही चालू करता हूं जहां से ये मूट कोर्ट की कल्पना स्टार्ट होती है और जैसे आगे बढ़ते हैं हम लोग। पहले स्वागत कर लें और धन्यवाद कर दें अपने चीफ गेस्ट का, जस्टिस SD सिंह साहब का। ये कहीं जाते नहीं है, बड़ी मुश्किल से हम बुला पाए हैं इनको। जस्टिस सिद्धार्थ, जस्टिस बनोट, दे हैव बीन टू दिस कॉलेज अर्लियर ऑल्सो, और इनका जब भी सहयोग हम मांगते हैं तो मिलता है, तो इनके लिए भी एक बार ताली हो जाए। तो मूट कोर्ट की जब हमने परिकल्पना करी और हमारी फैकल्टी मेंबर ने सोचा कि इस पे कुछ कार्य किया जाए, देन एक कुछ ऐसा सोचा गया कि मूट कोर्ट चूँकि हम इलाहाबाद में है, एक डिग्री कॉलेज है, हमें कुछ ना कुछ अलग से करना पड़ेगा जिससे लोगों को अट्रैक्ट कर सके इस कंपटीशन के लिए। तो फर्स्ट थिंग वी नीडेड वाज मनी, व्हाट वुड बी द प्राइज मनी सो दैट पीपल गेट अट्रैक्टेड। इलाहाबाद क्यों कोई आना चाहेगा, दिल्ली बम्बई तो सब जाना चाहते हैं। देन हमको मेरा हाथ पकड़ा या मेरी कॉलेज का हाथ पकड़ा सरला ट्रस्ट बॉम्बे ने, और हमको 4 लाख रुपए एवरी ईयर प्राइज मनी के रूप में वो देते हैं। तो पहला धन्यवाद सरला ट्रस्ट बॉम्बे का। उसके बाद वही बात होती है कि प्रॉब्लम कैसे बनेगी। ये सोचा गया कि प्रॉब्लम हमारी ऐसी होनी चाहिए जिसका उत्तर किसी जजमेंट में नहीं होना चाहिए, कि वरना सोचने की शक्ति का हरण होगा और हम ये नहीं सोच पाएंगे कि क्या सही है क्या गलत है, केवल सुप्रीम कोर्ट का या हाई कोर्ट के फैसले के बिना पे बता देंगे कि ये इसका आंसर है। तो वी गॉट सपोर्ट फ्रॉम एक हार्वर्ड की पढ़ी हुई लड़की है दीक्षा मनचंदा, शी इज़ अ पार्टनर इन चंद्रलोक एंड महाजन। वो पर्सनली इंटरेस्ट लेके हमारी प्रॉब्लम को बनाती हैं। शी ऑलवेज टेक्स केयर कि दैट वी डोंट फाइंड एन आंसर टू द प्रॉब्लम इन एनी जजमेंट ऑफ द सुप्रीम कोर्ट। तो उनका भी धन्यवाद कर देते हैं। एंड देन व्हेन वी गेट द प्रॉब्लम, उसको हम साइट पे डालते हैं। एंड दिस टाइम वी गॉट 45 इंस्टीट्यूशंस ऑल ओवर इंडिया गेटिंग देमसेल्फ रजिस्टर्ड विद अस। हमारे पास उसमें से 10 NLUs हैं, और कर्नाटक, आसाम, वी कुड टच आसाम, आसाम की टीम 16 में भी आई थी, लास्ट 16 में, गुजरात, बॉम्बे, दिल्ली, सब जगह की टीमों ने पार्टिसिपेट किया, एंड वी आर थैंकफुल to the students who have come all the way to Allahabad to be with us in this competition. जब 45 टीमों ने रजिस्टर किया, then we had to shortlist 16 of them for oral rounds. और उस काम के लिए हमको मेमोरियल जो आते हैं उनकी रीडिंग के लिए, उनको इवैल्यूएशन के लिए अपने हाई कोर्ट के वकीलों को पकड़ना पड़ा. हमारे हाई कोर्ट के वकील कुछ यहाँ मौजूद हैं, उनका धन्यवाद करते हैं फॉर being so considerate in evaluating the memorials and then making us shortlist the 16. फिर आती है बात, जब राउंड ऑफ 16 तय कर लिया तो उसका जजिंग कौन करेगा. फिर हाई कोर्ट के वकीलों का सहारा लिया, और आज हमारे सामने हमारे 16 जजेस हैं. उनको अभी स्टेज पे हमारे कंपेयरर्स बुलाएंगे, एंड वी विल इंट्रोड्यूस देम ऑल टू यू. हमारे क्वार्टर फाइनल राउंड में वी हैड 6 जजेस, जिसमें 2 बहुत रिसेंटली सीनियर एडवोकेट डिजिग्नेट हो गए हैं, तो उनका धन्यवाद है, मिस्टर राहुल अग्रवाल एंड निपुण सिंह. वो शायद नहीं आ पाए हैं. निपुण सिंह अगर आ गए हो तो हम दिख नहीं रहे हैं, तो उन लोगों ने सहायता करी. सेमीफाइनल के लिए हम लोग ने हमेशा से ये प्रैक्टिस अडॉप्ट करी है कि वी गेट जजेस फ्रॉम आउटसाइड, और अब की बार हमने वी हैड 3 जजेस फ्रॉम दिल्ली एंड 3 जजेस फ्रॉम बॉम्बे, और ये सब अपने इंडिविजुअल राइट्स में दे आर ईदर पार्टनर्स इन वेरी बिग लॉ फर्म्स और दे आर डूइंग प्रैक्टिस इन सुप्रीम कोर्ट. तो उन सब का भी धन्यवाद है. उनकी फ्लाइट थी, वो लोग चले गए, तो पर धन्यवाद ऑफिशियली मैं रिकॉर्ड कर देता हूँ उनके लिए, एंड विल बी आस्किंग देम टू प्लीज कीप कमिंग टू इलाहाबाद. फाइनल राउंड्स के जजेस आपके सामने थे, हमारे जस्टिस सिंह, जस्टिस बनोट, जस्टिस सिद्धार्थ. इनका धन्यवाद भी करना चाहिए, लेकिन मुझे लगता है कि अगर ये शिक्षा से नहीं जुड़ेंगे तो बाकी कौन जुड़ेगा. तो इनको तो आते ही रहना चाहिए हमारे विद्यालय में, और मूट कोर्ट को जज करते रहना चाहिए. थैंक यू ऑल फॉर बीइंग विद अस. हमारे साथ मिसेस सिंह है, उनका भी धन्यवाद है. आप लोग आ जाते हैं तो हिम्मत बढ़ जाती है, लगता कुछ अच्छा कर रहे हैं. जस्टिस अरुण कुमार है, उनसे अभी से वादा ले लिया है कि अगली बार उनको भी पकड़ेंगे कुछ ना कुछ करने के लिए मूट कोर्ट में. तो जस्टिस अरुण कुमार का भी धन्यवाद है. वी हैव 3 or 4 or 5 सीनियर एडवोकेट्स सिटिंग विद अस इलाहाबाद हाई कोर्ट के. दे ओनली कम टू विटनेस कि क्या कर रहे हैं विद्यालय में. अपना समय निकाल के हमारे सीनियर एडवोकेट्स आते हैं. तो HN सिंह साहब हैं, प्रमोद जी हैं, और बहुत सारे जजेस हैं, जिनका वकील है जिनका नाम अभी नहीं ले रहा हूँ. हमारी सोसाइटी के मेंबर्स हैं, बसंत जी हैं, महेश जी हैं, अमित जी हैं. दे ऑल कोऑपरेट. इनके बिना सहायता के शायद हम कोई भी आयोजन संभव नहीं है. दीज आर ऑल क्लास एक्शन, इंडिविजुअल कोई कुछ नहीं कर सकता है. तो ऐसे लोगों के लिए भी एक बार जोरदार ताली हो जाए जो पीछे से सपोर्ट कर. किसी भी संस्था को चलाने के लिए उसकी धुरी प्रिंसिपल होती है. एक प्रिंसिपल के लिए ताली हो जाए जोर से. हमारी लॉ की कोऑर्डिनेटर रिया सिन्हा, हमारी लॉ की फैकल्टी मेंबर्स और मूट कोर्ट कमेटी के मेंबर्स बहुत मेहनत करते हैं. आप लोग सोच नहीं सकते कितना काम लगता है. 8 कोर्ट रूम को तैयार करते हैं हम लोग एक दिन के लिए. विद स्टेज बनाते हैं, उसको ऐसा नहीं करते कि कुर्सी मेज लगी है और कंपटीशन कर लीजिए. वी प्रिपेयर अ कोर्ट, प्रॉपर कोर्ट, तखत लगेगा, उस पर मैटिंग होगी, उस पर कुर्सी मेज लगेगी, एंड वी हैव कोर्ट मास्टर्स जो सब काम करते हैं. तो जो कोर्ट मास्टर्स का जिन्होंने काम किया है और जिन्होंने स्टेज सजाया है, उन सब के लिए भी बहुत बहुत हम लोग आभारी हैं. बस अपने स्टाफ का भी धन्यवाद करेंगे, क्योंकि स्टाफ को बहुत बड़े बड़े तखत उठाने पड़ते हैं, और प्रिंसिपल हमसे कभी कभी कहती हैं कि ये क्या कराने, ये थक जाएंगे सब बेचारे, इसलिए एक दिन की छुट्टी दे दीजिएगा इनको. तो बस इसी पे अपनी सूचना को ख़त्म करूँगा. बस इतना रिक्वेस्ट जरूर करूँगा कि प्लीज़ डू कम टू दीज फंक्शंस. ये विद्यालय की जान है. अगर लॉ की बात करेंगे, अगर मूट कोर्ट नहीं होगा तो समझ लीजिए आज की तारीख में पढ़ाई अधूरी रह जाएगी. तो लेट अस कीप फाइटिंग फॉर गुड एजुकेशन. और आप कुछ नहीं कर सकते तो कम से कम आ तो सकते ही हमारे साथ. थैंक यू ऑल फॉर कमिंग. आखिरी में अपने कंपेयरर्स का धन्यवाद कर दें विदाउट कुछ कहे. सौम्या जी और रिया जी, they undertake the responsibility of not only doing the comparing, they also undertake the responsibility of preparing the students जो पहले कंपेयरिंग करके गए हैं. तो विद्यालय ऐसे चले, अच्छे से चले, आप आते रहें एंड हम लोग को उत्साह बढ़ाते रहें. दिस इज ऑल वी प्रे फॉर. थैंक यू ऑल फॉर कमिंग.
Thank you, sir. Justice Gopalji Mehrotra National Moot Court Competition rests on the generosity and kind consent of our evaluators, whose promptness and judicious decisions help us steer the competition to greater heights with every passing year. The institution expresses its deepest gratitude towards our evaluators for sparing their precious time and helping judge the competition by presenting them with a token of gratitude. I would first request Ms. Utkarshini Singh to kindly come on the stage. Ms. Ritu Verma is requested to do the honors. I now request Mr. Varun Singh to kindly come on the stage. Ms. Shweta is requested to kindly do the honors.
इसी क्रम में मिस्टर शिवांग यादव निर्णायक सदस्य को मंच पर आमंत्रित करते हैं. मिस्टर गौरव से निवेदन है कि आप निर्णायक सदस्य को सम्मानित करने में सहयोग प्रदान करें. मोहम्मद आतिफ निर्णायक सदस्य को मंच पर हम आमंत्रित करते हैं. डॉक्टर भाग्यश्री ओझा से निवेदन है कि आप सर को सम्मानित करने में सहयोग प्रदान करें.
Mr. Tanishq Goyal is requested to kindly come on the stage. Ms. Shivangi Shivi is requested to do the needful. Ms. Shushmita Mukherjee is requested to kindly come on the stage. Ms. Pragati Raj is requested to kindly do the honors.
मिस्टर प्रणव तिवारी निर्णायक सदस्य को मंच पर आमंत्रित करते हैं एवं डॉक्टर अपूर्वा सिंह से अनुरोध है कि आप सर को सम्मानित करने में सहयोग प्रदान करें। मिस्टर ऋतिज विक्रम सिंह से अनुरोध है कि आप मंच पर आएं। सर को सम्मानित करने हेतु मिस प्राची कुमारी से निवेदन है कि आप औपचारिकताओं का निर्वहन करें।
Ms. Shambhavi Gupta is requested to kindly come on the stage. Mr. Pratyush Pandey is requested to do the honors. Mr. Shashank Bhatt is requested to kindly come on the stage. Ms. Anshi Agarwal may kindly do the honors.
मिस्टर अभिनव गौर निर्णायक सदस्य को हम मंच पर आमंत्रित करते हैं। आपको सम्मानित करने के उद्देश्य से मिस रिया सिन्हा से आग्रह है कि आप सर को सम्मानित करें। निर्णायक सदस्य मिस प्रियंका मिधा, आपसे सविनम्र अनुरोध है कि आप मंच पर आएं। मैम को सम्मानित करने के उद्देश्य से डॉक्टर मोहिनी शुक्ला से निवेदन है कि आप औपचारिकताओं का निर्वहन करें।
Thank you, everyone. In order to ensure transparency, the Institute invites judges from outside Uttar Pradesh to judge the semi-final rounds every year. This year, we had Ms. Vidushi Gupta Bagri, Mr. Tarumai Chaudhary, Mr. Abhay Pratap Singh, Ms. Shubhangini Jain, Mr. Anirudh Kapoor, and Mr. Pranay Bagri. The Institute expresses its deepest gratitude to them. Research fuels a good litigation, and a good researcher is the keystone to an informative argumentation. Now it is time to recognize the best researcher. The award for the best researcher in the third Justice Gopalji Mehrotra Moot Court competition goes to Ms. Anandita Dhingra Insa of UIC 128, Rajiv Gandhi National Law University, Punjab. I request Mrs. Anshika Budbar, Treasurer, Governing Body, SS Khanna Girls Degree College, to kindly give away the award. Dr. Vinita Mishra, Proctor, may kindly assist in giving away the award. Please give a round of applause to the winner. The winner receives an award of rupees 30,000, check, trophy, certificate, and flex.
प्रतिभागी को शुभकामनाएं। निश्चय ही इस सभागार में बैठे प्रतिभागियों को विजेता के नाम की तलब होगी। उन्हें उसकी इच्छा उत्पन्न हो रही होगी कि जल्दी से विजेता का नाम उद्घोषित किया जाए और वो जाए, लेकिन आपके सब्र की परीक्षा अभी और लेनी है। इसलिए विजेता के नाम की उद्घोषणा से पहले हम अन्य जो एंट्रीज हैं उसकी उद्घोषणा करेंगे। समय है सर्वश्रेष्ठ वक्ता या बेस्ट स्पीकर प्रतिभागी के नाम की उद्घोषणा का, और यह पुरस्कार जाता है UIC 136 मिस अग्रिमा रमन। मिस अग्रिमा रमन धर्मशास्त्र राष्ट्रीय विधिक विश्वविद्यालय जबलपुर से इस प्रतियोगिता में प्रतिभाग कर रही हैं। पुरस्कार हेतु हम माननीय न्यायमूर्ति श्री अजय भनोत सर से आग्रह करेंगे कि आप मंच पर अग्रसित हों। इस कार्य में डॉक्टर आरिफा बेगम से निवेदन है कि सर को सहयोग प्रदान करें। प्रतिभागी को 30,000 रुपये की राशि का चेक, फ्लेक्स, ट्रॉफी व प्रमाण पत्र प्रदान किया जा रहा है। प्रतिभागी को शुभकामनाएं। माननीय न्यायमूर्ति श्री अजय भनोत सर से सविनम्र अनुरोध है कि आप अपने प्रेरणादायी वक्तव्य से हमारे प्रतिभागियों, छात्राओं एवं इस सभा को संबोधित करें। सर प्लीज।
SD Singh, my Lord Justice Siddharth, Justice Arun Tandon, Principal of the Institution Management, Brother Justice Arun Kumar, or Hardil Aziz students. So there has been a slight, I was literally taken aback by this request because I thought in the order of precedence, it is the chief guest who will be giving his most learned views, and I would simply have to adopt them. sitting as we do in a division bench or a full bench. And honestly, with that thing in my mind, I was quite secure that I'll not be called upon to speak and expose myself. So I didn't bother preparing a speech. But I was honestly very, very pleased and really heartened to see some of the young students coming up, raring to go into the profession. So our conversation was cut short, and I think I will not give a speech per se, but I will just take our conversation forward. So the young students who had come, they were looking for a career in litigation, as I could understand. And obviously, they are first generation to be lawyers. I can empathize with them. So children, when you step out from this wonderful institution, you will find yourself very much prepared to meet the challenges of the profession. I have been observing this institution for a couple of years now, and the grounding, I have no hesitation in saying that the grounding that you get with such a committed management, faculty geared to excellence, you will be very well prepared to live your dreams in the profession. So I will just, as I said, that I'm not going to make it a formal speech. I will share some of my experiences at the Allahabad High Court, which I felt held me in good stead over the years. So both the perceptions when I came into the profession and how the training of this institution helped me out, and I retained those perceptions. When I came into the profession, much like all of you, my heart was always seeking for a lot of self-fulfillment. But I was also assailed by doubts, because the legal profession, I'll not mince words, does not lend itself to success very easily. So when I started the profession, I got into the discipline of the chambers of my senior, Sri Rakesh Dwivedi, senior advocate, and subsequently Sri Ashok Khare, senior advocate. And the tradition and which the methodology which they were following in the chambers at that point in time continues to be my firmest pillar of strength in this changed role as well. So what is that methodology which we follow? So in the evenings, children, first of all, regularity. Regularity in attending your chambers and your courts. That's the first thing. Or rather, let me put it this way, I'll go one step backwards. Your health. Your health is something which you take for granted. Now, that is something, as you move on in years, you will realize that you have to keep constantly working on your health, both physical, mental wellness, and development of, and conscious cultivation of good character qualities by constant introspection. So that is one aspect, a very critical aspect, because our educational system, as it is geared to testing you only on a question and answer format, maybe sometime you have some exposures by way of moot courts, but your career in the law is about your experiences in life. So how do you deal with that? As a lawyer, you may be a very bright lawyer, might be knowing all the case laws, but that alone does not go into making a good lawyer. And that's the experience that I got from the discipline of the chambers, as I like to call it. I am reminded of one incident which Satya Nadella quoted in his book, Hit Refresh, which is very, very relevant, I find, as a lawyer, and on this side also I still consider myself as a lawyer. You know, when he was facing an interview with the Microsoft corporation at the time of his induction, so one would expect that the interview board would be emphasizing more on very, very technical issues of computers and computing. But the question that he was asked was that, you know, you see a small baby, 10-month-old infant on a roadside crying, what do you do? So he said, I'll call up 911. So the interviewer put his arm around him and took him aside and said that, look, son, when you see a child on a roadside, an infant, you lift the child and caress and comfort the child. You don't call 911. So ordinarily you'll be expecting that it is only cutting edge computer science knowledge that will give you a ticket to success in a corporation like Microsoft, but that is not to be. As you saw from this incident, there are a lot of other qualities which matter. In the legal profession, similarly, a lot more, it is your overall personality and your attitudes to life, towards your colleagues, towards your clients, seniors, staff of the court, the judges, all that makes up a lawyer. So honestly telling you, it is your own education that you're going to set up when you get into the profession. So be very careful about the course structure that you set up. Your life values, your health comes first always and every time. Second, regular reading of the laws. Regular reading, by that I mean that you open your journals, keep writing. You know, have your registers, separate registers for separate fields of law. My seniors would tell me that, Ajay, start reading and within 6 months, you will be a changed man. Of course, 6 months, I was not so much the wiser or the better. It took me a fairly long time, but I did realize the wisdom of those words much later in life, because you will realize that over the years, suddenly, subtly, you will be stealing a march over yourself. Second, only self-competition. Set your own goals. Don't compare yourself with others. Someone might get better briefs before you, but no, it is your own self, your own satisfaction, how you are setting your goals, how you are preparing for them. Third, reading in general. Your reading should be as vast and as varied as possible. You know, there's a beautiful saying, and I will share this experience with you, that I used to subscribe to those journals called company cases. I had few and far between cases. My Lord Justice S.D. Singh was a known corporate and tax lawyer. But I still continued to subscribe to those cases, and some of my colleagues at the bar would say कि यार इसमें तो सिर्फ ज़्यादातर most of the cases pertain to oppression and mismanagement. इससे क्या करोगे तुम? कंपनी लॉ ट्राइब्यूनल कैलकाटा में है, दिल्ली में है. What do you do with that? So why you subscribing? बस वो उतना होता है, winding up के cases और amalgamation के होते हैं where the court takes over, you just have to do. But I still persisted. For some reason, I like to believe that I might become a great lawyer someday. So, you know, lo and behold, a colleague of mine said that, you know, what do you think? The tribunal will come here or what? I said, nahi, maybe agar aage jana hoga, Delhi shift karna hoga. So, lo and behold, the tribunal, the NCLT came to Allahabad after the insolvency code was introduced. Insolvency and bankruptcy code. The second great desire that I had was that I wanted to win an election at the bar. But I was equally confident that even I won't vote for myself. So, being a very dear friend, my Lord Justice S.D. Singh understood that on his own steam, this man can never win an election. So when we formed the Bar Association at the NCLT, he was there with another esteemed senior of mine, who again had a shine for me, and he said that, okay, Ajay is going to be the president of the association, and since he is going to be the founder member, no one else will contest him. So that's how my greatest ambition came to be. So that is one aspect. The second aspect, children, is that never stop learning. Always be humble, because it is your. I want to share one secret today with all of you, which I do in the courts also, that there is nothing to feel shy about anything. As a lawyer, I had got designated as a senior advocate. And at times, I would get off and on matters of income tax. And there was only one lawyer who knew income tax. Again, my Lord Justice S.D. Singh. So I would take time from him at about 10 o'clock at night after all his clients had left. And Bhabiji would be very kind to permit him to sit beyond chamber hours, and we had nice coffee, and he would discuss with me. Of course, he had full right to reprimand me for my obtuseness, if I may say. But then at the end of it, he made sure that I was well prepared and could hold my own in the tax cases also. So you may be anything, but don't feel shy of learning, because that is what takes you forward. The third thing was, now that is something which is again an experiment that I have found to be reasonably successful in my life. I can share that with you. There's a Swami Vivekananda saying, somewhere he said that manifest the divinity within yourselves and everything else will arrange itself harmonically around it. So what is the divinity within you? A divinity for a young lawyer will be to regulate his lifestyle, to work hard, as I said, the chamber discipline of reading, writing the law journals, and don't go by the digital mode, because recently I had a young lawyer coming up. I said, "Aap register bana rahe nahi bana rahe?" Nahi, acha hum banayenge. I said, next time you will be heard only if you are having those registers. So again he came up the next time, and I said, "Are you there?" He says, "Yes, मैंने अपने iPad पे कर लिया है." So whenever I read the judgment, I just click save, and it is saved. So that's not the idea. The idea is, I was reading some time back an article in the Reader's Digest, that you're able to absorb things if you use three faculties. I don't know, Dr. Sareen is here, how far I'm correct scientifically. If you use your hands, your heart, and your mind. So when you're writing, I'll give you an example. A word cognizance is used in the Criminal Procedure Code. You would have learnt it. Maybe you can answer it also, a question. But if you read it in the context of a judgment and take it down in your registers 4 times, that is going to mingle with the red blood in your veins. You'll be so thorough. Children, knowledge is power. No few other professions give you that insight of knowledge being power as the legal profession. I like to tell the lawyers, it is up to you to have the knowledge and retain the power with yourselves. Because if you don't have the knowledge, then the power will move to the judge. So knowledge is power. Third thing, children, never give up hope. Never give up your humanity. Fill yourselves with that same unquenchable optimism with which you came to this college and with which all of you met me today. Because in all of you, I saw the future of the profession. I saw the future of our country. And go ahead, in the words of Swami Vivekananda, Uthishtit Jagrat Prapya Varani Bodhat. Arise awake, stop not till the goal is reached. Jai Hind, God bless you all.
धन्यवाद सर। निश्चय ही सफलता का मोती कठोरता की सीपी में पनपता है। आपने एक अच्छे अधिवक्ता के गुण सिखाते हुए कहा कि निरंतरता, उदात्त व्यक्तित्व, आत्म प्रतिस्पर्धा, अध्ययन, मानवता और उम्मीद एक अच्छे अधिवक्ता के गुण हैं जिन्हें आप हमेशा सजो कर रखें। सर, महाविद्यालय सदैव आपके प्रति एवं आपके आगमन से कृतार्थ है। इसी कृतज्ञता स्वरूप एवं सदैव आपकी स्मृतियों में बना रहने के उद्देश्य से एक स्मृति चिन्ह प्रदान करना चाहता है। महाविद्यालय प्रबंध समिति के उपाध्यक्ष श्री दिलीप मेहरोत्रा सर से अनुरोध है कि आप सर को स्मृति चिन्ह व अंगवस्त्र प्रदान करें। सर, आपसे निवेदन है कि आप मंच पर अग्रसित हो। माननीय न्यायमूर्ति श्री अजय भनोट सर, डॉक्टर शिव शंकर शुक्ला सर से अनुरोध है कि आप सर को इस कार्य में सहयोग प्रदान करें।
Thank you, everyone. Now it's time to give away our next award. And the next in the series of award is the award for the best memorial. The award for the best memorial for the third Justice Gopalji Mehrotra Moot Court Competition 2025 goes to UIC 130, Vanasthali Vidyapith, Rajasthan. The team members, Sukriti Chaudhary, Tanya Tripathi, and Tanisha Bijlani, may please come to the stage. I request our esteemed guest, Honorable Mr. Justice Siddharth, to kindly give away the award. I request Professor Sangeeta Gautam to kindly assist in giving away the award. The winners receive an award of Rs 30,000, check, certificate, trophy, and flex. Please give a round of applause to the winners. Thank you, sir. I now request Honorable Mr. Justice Siddharth to kindly bless the participants and students of SS Khanna Girls Degree College.
समय काफ़ी हो गया है, तो किसी भी औपचारिकता का निर्वाह किए बिना मैं सबको प्रणाम करता हूँ। अपने भाइयों को, सभागार में उपस्थित भाभी जी लोगों को और सारी शिक्षिकाओं को, बच्चों को, सबको आशीर्वाद। रही बात अब कुछ बोलने के लिए बचा का, मनोज साहब ने सब बता दिया आपको। अब आप लोग अगर उतना ही सीख लिए तो बहुत बड़ी बात है। उतना अगर आप लोग समझ गए तो आप बहुत बड़े वकील बनेंगे, इसमें कोई दो राय नहीं है। लेकिन उसके साथ हम थोड़ा और भी जोड़ना चाहते हैं। आई वुड लाइक टू ऐड कि कानून जो है तो एक कागज़ पे लिखा हुआ काला और सफ़ेद में कुछ शब्द हैं। सिर्फ उसको समझने से कोई वकील नहीं बनता, ना बड़ा जज बनता है। आपको इंसान को समझना पड़ेगा, इंसान की हरकतें समझना पड़ेगा। कोई इंसान किस परिस्थिति में क्या काम करता है, किस तरह उसका दिमाग चलता है, ये आपको समझना पड़ेगा। कभी भी अच्छा जज, अच्छा वकील वो नहीं होता जो समाज के साथ इंटरेक्ट नहीं कर पाता। इसीलिए वकालत बहुत ज़रूरी है। लिटिगेशन में आप लोग जाइए, और लिटिगेशन में वाकई जाइए, ये नहीं कि 3 साल तक वकालतनामा लगा के जुडिशरी का इम्तहान दीजिए, मत करिए ऐसा, प्लीज़ डोंट डू दैट। आपको कभी बड़ा तो वकील बनेंगे नहीं, कभी जज बनेंगे बड़े। जो लोग 5 ईयर 5 ईयर लॉ कोर्स करके जज बन गए हैं, जिन्होंने कभी कोर्ट देखा नहीं था, जिन्होंने कभी क्लाइंट से बात नहीं किया था, आज वो कितनी बड़ी समस्या हमारे यूपी में तो खास करके जुडिशरी में ऐसे अधिकारियों की भरमार है जिन्होंने कभी काम नहीं किया, उनका कोई इंटरेक्शन समाज से नहीं था, बस खाली पढ़ाई किया और अब जज बन गए। आपको समझ में नहीं आएगा कि बेचारा जो सामने खड़ा हुआ है इसने ऐसी गलती क्यों किया। एक बड़ा से बड़ा क्रिमिनल भी आप उससे बात करेंगे जब, तो बताएगा, उसके पास एक जस्टिफिकेशन होता है कि क्राइम हमने क्यों किया। तो वो जस्टिफिकेशन समझने के लिए इंसान की ज़रूरत होती है, और सिर्फ कानून को अंधे की तरह अप्लाई कर देना तो फिर कंप्यूटर भी कर सकता है। आप अब एआई से फैक्ट फीड कर दीजिए मुकदमे का, रेलिवेंट डॉट डाल दीजिए, वो एक जजमेंट बना के दे देगा। तो इंसान की क्यों ज़रूरत पड़ती है? इसलिए पड़ती है कि इंसान की प्रॉब्लम, इंसान क्यों किस तरह काम करता हो, वो इंसान ही समझ सकता है। इसलिए एक जज की ज़रूरत होती है या एक वकील की ज़रूरत होती है जो उसके केस को उस तरह से प्रेजेंट करे कि किस परिस्थिति में उसने ये काम किया। तो इसलिए हम चाहेंगे कि आप लोग लिटिगेशन में जाएं, और जो आपके पास क्लाइंट आता है बेपढ़ा लिखा अंगूठा टेक क्लाइंट, उससे भी बात करिए। जब आप उससे बात करेंगे तो आपको समझ में आएगा कि इस बेचारे की क्या मुसीबत थी जो इस मुसीबत में फंस गया, या क्यों ऐसा कर रहा है, इसकी क्या वजह थी। और सोसाइटी में इतने तरह के लोग हैं, वकील और जज का पाला, कहते हैं देवता से दानों तक का रेंज है, फ्रॉम गॉड टू डेमन। यू विल मीट पीपल फ्रॉम गॉड टू डेमन इन दिस प्रोफेशन, और सबको समझने का मौका मिलता है। आपको सब समझ में आ जाएगा, पुलिस कैसे काम करती है, एडमिनिस्ट्रेशन कैसे काम करता है, गुंडा कैसे काम करता है, नेता कैसे काम करता है, और जो अखबार में लिखा रहता है वो कितना सही है और कितना गलत होता है। मुकदमा जो बन के आता है वो कहाँ सही है और कहाँ गलत है। वो जब तक आप इंसान को नहीं समझेंगे तब तक आप न्याय नहीं कर सकते अपने क्लाइंट के साथ, और एज जज आप भी तब भी न्याय नहीं कर सकते। इसलिए जो प्रैक्टिकल लाइफ है उसको जीने की कोशिश करिए, इंसान को समझने की कोशिश करिए, थोड़ा लिटरेचर भी पढ़िए, थोड़ा सोसाइटी में भी जाइए, सामाजिक काम करिए, तब आपको समझ में आएगा कि लोग कैसे होते, दुनिया कैसे चलती है। क्योंकि आज की जो पीढ़ी है बहुत प्रोटेक्टेड, आप लोग जिस एनवायरनमेंट में बड़े हो रहे हैं, मैक्सिमम 1 या 2 बच्चे हैं पेरेंट्स के, आप बहुत ही प्रोटेक्टेड एनवायरनमेंट में पढ़े हैं, बड़े हुए हैं। आपको आपका एक्सपोजर समाज के प्रति ज़ीरो है, आप जानते नहीं कैसी कैसी मुसीबत समाज में है और कैसे कैसे लोग हैं, उनकी क्या क्या परेशानी है। आप बहुत प्रोटेक्टेड एनवायरनमेंट में, हमारी जनरेशन में 5-5 6-6 बच्चे होते थे, माँ बाप के, भाई बहन होते थे, तो मीन्स ऑफ सर्वाइवल कम होते थे, तो हम लोगों ने स्ट्रगल किया, तो बहुत तरह के लोगों से इंटरेक्शन हुआ, वो सब हम लोग जानते थे। आज जज होने के बाद उन सब चीज़ों का फ़ायदा मिलता है, वकालत में भी मिला, उसको डिफेंड करने के लिए, अपना केस पुटअप करने के लिए। इसलिए मैं कहूँगा कि इंसान को समझने की कोशिश करिए, थोड़ा बहुत कानून आ जाएगा तो कोई बात नहीं। लॉर्ड डनिंग कहते थे, अ लिटिल बिट ऑफ लॉ विल डू, द पर्सन हु अप्लाइज द लॉ शुड बी अ गुड मैन और अ गुड पर्सन। तो ट्राई टू बी अ गुड पर्सन। जब आप अच्छे इंसान बन जाएंगे तो आप अच्छे जज भी बनेंगे, अच्छे वकील भी बनेंगे, आपकी पैसे की लालच नहीं रहेगी। आप फिर एक काम को करेंगे जो वकालत और जजी का काम है, ये एक बहुत बड़ा सोशल रिस्पॉन्सिबिलिटी है आपकी। गलत आदमी जीत जाए ये आपके लिए भी दुर्भाग्य होता है। और मैं ऐसे भी वकीलों को जानता हूँ, हमारे हाई कोर्ट में एक थे मिस्टर KBL गौड़ साहब, सिविल के बहुत अच्छे वकील थे। एक सिविल के सेकंड अपील वो जीत गए, हमको बता रहे थे वो ये कहानी, बेटा देखो वकालत कैसे होती है। जीत गए, वो घर चले गए, बोले हम रात भर सो नहीं पाए क्योंकि हमको लगा कि हमारा मुक्किल तो गड़बड़ था, लेकिन वो इतने काबिल वकील थे कि जज साहब को उन्होंने अपनी बात में बांध लिया। वो घर गए, रात भर सो नहीं पाए, दूसरे दिन उनके चेम्बर में गए तो उन्होंने कहा साहब वो जजमेंट आपसे गलत हो गया, और हमने भी गलत बहस तो किया, हमारा तो धर्म था, लेकिन आपको सही बात बताना है। तो फिर उन्होंने जजमेंट रिवर्स कराया उनको लगा कि नहीं अन्याय हो जाएगा और इससे समाज में गलत, बोले हम मुकदमा हार गए लेकिन न्याय जीत गया है, वो हमारी खुशी थी। तो ध्यान रखिएगा, आप हारे या जीते, आपका मुक्किल हारे या जीते, न्याय को जीतना चाहिए। हमारा एम न्याय को जिताना होता है, किसी व्यक्ति को नहीं होना। और क्लाइंट, आप मान लीजिए आप किसी क्लाइंट से हार भी जाता है आप उसकी तरफ से, लेकिन उसको लगता है कि हमारे वकील साहब सिंसियर हैं, तो आपका खिलाफ पार्टी भी आपको इंगेज करेगा। मुझे किया है, मैं वो केस लूज़ कर गया था लेकिन खिलाफ पार्टी मेरे पास मुकदमा लेके आया, बोला ये क्या हुआ, कहन साहब हार तो गए थे, आप हार गए थे, हम जीत गए थे, लेकिन हमें लगा नहीं आप ठीक आदमी हैं क्योंकि आपने सही बात बताई थी कोर्ट को, इसलिए हम आपसे मुकदमा कराएंगे। इसलिए बस इतना ध्यान रखिएगा, कानून पढ़ना समझना अपनी जगह है, लेकिन इंसान को समझना बहुत ज़रूरी है। जिस दिन आप इंसान को समझ जाएंगे, बहुत बड़े वकील भी बन जाएंगे और इस सिस्टम के लिए बहुत बड़े एसेट हो जाएंगे। 3 साल का सबको समय मिला है जो जुडिशरी में जाना चाहते हैं, 3 साल कचहरियों में, हाई कोर्ट में, जहाँ भी जाना हो जाइए। सबसे अच्छा जो रियलिस्टिक स्कूल है सिखाने का वो कचहरी है। जो डिस्ट्रिक्ट कोर्ट चला जाता है उसको समझ में आ जाता है कानून कैसे अप्लाई होता है, क्या होता है कानून। हम तो इंटरव्यू में पूछते थे बच्चों से, कभी कोर्ट गए, जज बनने आ गए, बोले नहीं। पापा वकील हैं, हाँ, तो कभी पापा के साथ बैठे, नहीं बैठे। अब वो सब बच्चे जज बन के आ गए हैं, वो ठीक से बात तक नहीं करते, वकीलों को ऐसा ट्रीट करते हैं जैसे वो चपरासी हों। तो वो क्यों आता है, ऐसा टेंडेंसी क्यों आती है? उनको लगता है हमें क्लास अपार्ट है, जबकि उन्हीं बच्चों से हम लोग जाते हैं तो कहते हैं बड़े वकीलों से, काबिल वकीलों से कुछ सीखिए आप लोग। आप जो 10 किताब पढ़ के सीखेंगे वो आपके वकील साहब उनके टिप्स पे होता है, 2 मिनट में बता देंगे ये रेलिवेंट लॉ है, ये देख लीजिए, आपका काम हो जाएगा। मगर उनको ट्रेनिंग दी जाती है कि नहीं नहीं वकीलों से ज़्यादा बात मत करो। हम कहे बात मत करो भाई, दोस्ती करने को थोड़ी कह रहे हैं, उनसे जो ज्ञान है वो ले लो, ज्ञान तो कहीं से मिले ले लो, ज्ञान लेने में क्या फ़र्क, तो कहीं से भी ज्ञान मिल सकता है। इसलिए ज्ञान लेने से परहेज न करें, गलती हो जाए वो भी मानने से परहेज न करें। कई बार हम लोग से भी गलती होती है, रिव्यू लगता है, मान लेते हैं हो गई गलती, तो गलती से भी परहेज न करें। ध्यान रखें, न्याय को जीतना है, किसी व्यक्ति को विशेष को नहीं जीतना है, किसी पार्टी को, किसी वकील को नहीं जीतना है। धन्यवाद, आप लोग ने हमारे भाषण सुना।
Thank you, sir. Your ideas on bridging the gap between legal education and legal practice, I'm sure, has been an eye-opener for our students. The time you spent with us here today is precious, and in order to keep the memories of this day alive in your mind, the Institute would like to present you with some memorabilia. I request Mr. Amit Khanna, member Saraswat Khatri Pathshala Society, to kindly do the honors. Dr. Sameer is requested to kindly assist, sir.
धन्यवाद। अब क्षण है जिसकी प्रतीक्षा कल से हो रही है, जिसके लिए ये सारा मनोयोग किया गया। हमारी दोनों ही टीम UIC 122 एवं UIC 117 ने अपना सर्वश्रेष्ठ प्रयास किया और दोनों ही टीम ने हमारे लिए विजेता हैं। कुल 43 प्रविष्टियों में से 16 सर्वश्रेष्ठ टीम के रूप में चयनित होने के पश्चात विभिन्न चरणों से होते हुए फाइनल तक पहुंचना, ये अपने आप में एक बड़ी बात है। आप सब दोनों प्रतिभागी टीम के लिए जोरदार तालियां। शारीरिक रूप से अस्वस्थ होने के बाद भी आपका साहस और जज्बा कम नहीं हुआ, यह निश्चित रूप से सराहनीय है और हम सभी आपकी प्रशंसा करते हैं। समय है तृतीय जस्टिस गोपालजी मेहरोत्रा राष्ट्रीय मूट कोर्ट प्रतियोगिता 2025 की विजेता टीम की उद्घोषणा का। एनी गेसेस? तृतीय जस्टिस गोपालजी मेहरोत्रा राष्ट्रीय मूट कोर्ट प्रतियोगिता 2025 की विजेता टीम है UIC कोड 117। माननीय मुख्य अतिथि महोदय न्यायमूर्ति श्री SD सिंह सर, प्राचार्य प्रोफेसर लालिमा सिंह मैम व सरोज लालजी मेहरोत्रा विधि संकाय की समन्वयक डॉक्टर रिया मुखर्जी से अनुरोध है कि आप विजेताओं को पुरस्कृत करने हेतु अग्रसित हों। डॉक्टर सिप्पी सिंह समन्वयक विज्ञान संकाय से निवेदन है कि आप आवश्यक सहयोग प्रदान करें। UIC 117 चंडीगढ़ विश्वविद्यालय पंजाब से हमारे इस प्रतियोगिता में प्रतिनिधित्व कर रही थी। विजेता टीम को 2 लाख रुपए की राशि का चेक, फ्लेक्स, ट्रॉफी व प्रमाण पत्र प्रदान किया जा रहा है। अब हम अपने प्रतिभागियों के नाम की भी उद्घोषणा कर सकते हैं। UIC 117 से प्रतिनिधित्व कर रहे थे मिस्टर अरविंद, मिस्टर ईशान लखन व मिस्टर गुरिस्ट मित्तल। तालियों की गड़गड़ाहट कम नहीं होनी चाहिए। निश्चित तौर पर हमारी दोनों टीमों का प्रदर्शन उत्कृष्ट रहा, लेकिन प्रतियोगिता की बाध्यता है कि कोई एक विजेता होगा और कोई एक उपविजेता। इसके साथ ही हम UIC 122 को मंच पर आमंत्रित करते हैं व मुख्य अतिथि महोदय प्राचार्य एवं विधि संकाय की समन्वयक से निवेदन है कि वह प्रतिभागियों को सम्मानित करें। इस कार्य में सहयोग हेतु डॉक्टर हरीश सिंह शिक्षा शास्त्र विभाग से अनुरोध है कि आप पुरस्कार वितरण कार्य में सहयोग प्रदान करें। विजेता टीम UIC 122 चाणक्य राष्ट्रीय विधि विश्वविद्यालय पटना से इस प्रतियोगिता में प्रतिनिधित्व कर रही थी तथा इस टीम के प्रतिभागी हैं ओजल मौर्य, अमन रुंगटा व कुंदन राज। प्रतिभागियों को पुरस्कार स्वरूप 1 लाख रुपए की राशि का चेक, फ्लेक्स, ट्रॉफी व प्रमाण पत्र प्रदान किया जा रहा है। उपविजेता टीम के लिए और जोरदार तालियां उनके उत्साहवर्धन के लिए। दोनों ही टीमों को कोटिशः शुभकामनाएं। माननीय मुख्य अतिथि महोदय न्यायमूर्ति श्री SD सिंह सर से निवेदन है कि आप अपने वैदुष्यमय एवं वैविध्य व्यक्तित्व व अनुभव से निश्चय ही हमारी छात्राओं को मार्गदर्शित करेंगे। आपसे सविनम्र अनुरोध है कि आप अपने आशीर्वचन से इस सभा में प्रतिभागियों व छात्राओं को अभिसिंचित करें।
नमस्कार। ब्रदर जस्टिस सिद्धार्थ, ब्रदर जस्टिस अजय भनोट, प्रोफेसर लालिमा सिंह, बड़े भाई ब्रदर अरुण टंडन, फॉर्मर जज इलाहाबाद हाई कोर्ट, जिनके आदेश की स्ट्रेंथ कही है या उसका इम्प्लीमेंट करने का एडमिनिस्ट्रेटिव और अथॉरिटीज़ को ही नहीं जुडिशल पे भी वर्क करता है कि उनका एक निर्देश था तो उसका पालन होना ही था. एंड जैसा उन्होंने कहा आई हैव स्टेज फ्राइट, सो आई अवॉइड. बट इन्होंने कहा तो आना था. ब्रदर जस्टिस अरुण कुमार, Ms. Anshika Budhwar, all members of the organizing committee, learned senior advocates who have found time, learned advocates of the Allahabad High Court who have made time, all faculty members, all college lecturers, teachers, everybody, and staff who have made this program possible, and what I would say a grand success. Thank you. And students, well, you are the life and blood, as if I can borrow that phrase from Justice Ajay Bhanot's words. First things first, I neither have the eloquence and the brilliance of Brother Justice Ajay Bhanot and the humility with which he will put his thoughts. I was just saying, he has told you some things and he's mentioned my name twice. But since I am having the last word and not giving him any opportunity thereafter, may I make it clear he was just making his point clear and using me as a prop. So he used me as a prop. He has been a great learner and a hard-working advocate. And he comes from a very different background, but that has helped him because he comes from an army background and he is therefore more disciplined than any of us. And he had the passion to do what he set his eyes on. And that is what has brought him here. Brother, I also do not have the pragmatic and humanistic approach of Brother Justice Siddharth, जिन्होंने आपको बिल्कुल सरलता से सीधे डायरेक्ट अनुवाद किया है. जो हार्ड रियलिटीज़ ऑफ लाइफ हैं उसको उन्होंने आपको बिना किसी पर्दे के, बिना किसी जिसको कहिए शुगर कोटिंग के, ब्लंटली आपके सामने रखा है. So if I were to borrow that tagline of an advertisement which was very catchy in years gone by, जोर का झटका धीर से लगे, तो वो आपको वो उन्होंने काम किया है. दैट इज़ हिज इंटेंट कि अब आप जब रियल वर्ल्ड में स्टेप आउट करेंगे इस मूट कोर्ट एनवायरनमेंट, इस कॉलेज टीचिंग से, तो आपको कहीं शाय अवे नहीं करना है. आपको जिम्मेदारी जहाँ आएगी वो लेनी है, और लेने में कोई वो नहीं कि हमको क्या होगा. डोंट बॉदर, जस्ट डू. सो इफ आई कैन नाउ add a few words, though you will find it dull and drab, and we have reached the end also, and I have really nothing to add, but still, so that just to say something boring so that bade bhai humko agli baar nahi bulayenge. So it's been a privilege and a genuine pleasure to witness. So you can already make out that I don't have the eloquence. I have to read from what I have prepared, that too with some help. So it's a privilege and genuine pleasure to witness the depth of intellect and the passion with which the participants have participated in this competition. Over the course of today's round, we saw spirited arguments, meticulous research, and above all, a commendable commitment to understanding and upholding the principles of law. As experienced professionals, the three of us, we can claim we are, having worked as lawyers at the Allahabad High Court and also as judges now for some time, believe us when we say that all arguments that you were advancing, whether for or against, were thought-provoking, were largely original also when it was coming to relating to the facts. You have relied on precedent, but yes, you have thought about it. And that is what is the first attribute of a lawyer. To think you need to question. Why? What is given to you is like in a chemistry lab situation, you are given certain salts, certain chemicals to begin with when we have been in school and studied chemistry to some extent at least. So then those are the facts given to you. You've been, one side was engaged got the lottery, perhaps I believe in the lottery system, to present the case of the petitioner, the other of the respondent. Now, it is very simple in our profession, it has been. The facts are not of your making. So that basically may govern the outcome of the proceedings always, whether in a moot court
or in a real world. What is required of a lawyer is the process of distillation that he undertakes to distill the facts through the processes of law, in the context of law, if I may say. बहुत सारे फैक्ट्स आपको बता देगा, आपको कोई भी, वेदर यू गो इन अ कॉर्पोरेट सिचुएशन, कॉर्पोरेट लॉयर बनिए आप चाहे प्रैक्टिस में आइए, इंडिविजुअल पिटिशनर का करिए, फंडामेंटल राइट्स के लिए लड़िए, criminal, civil, wherever, he will tell you a lot of things. But it is your learning comes into play because आपके पास वो केमिस्ट्री लैब के सॉल्वेंट्स एंड सॉल्ट्स हैं जिनसे आप एग्जामिन कर पाएंगे कि क्या चीज़ कह रहा है जो इसको कानून में हमारे यहाँ जो एग्जिस्टिंग है उसमें इसको रिलीफ दिला सकें और कहाँ तक उसकी बात जायज़ है. Sometimes as one of our old judges, बड़े भाई साहब को याद आएगा कि वो कहते थे, उनका बड़ा एक ऑफ्ट कोटेड फ्रेज था, कोट, यू कैन आस्क फॉर द मून. तो मतलब ये कि कोर्ट में अगर किसी ने रिलीफ ऐसा मांग लिया जो नहीं मिलना है तो वो ये नहीं कहेंगे, वो मज़े में ऊपर से ही आता था, यू कैन आस्क फॉर द मून, मिलेगा नहीं. सो दैट इज़ द टेबल वर्क दैट इज़ रिक्वायर्ड. You will have to always, you cannot choose your clients, you cannot choose their facts, you cannot mislead the court. You are sworn to tell the true, vote before the court with the true facts to the extent you can find out. You're not to self-implicate, वो नहीं करना है, उसका client को हराना नहीं है. And that जो brother ने refer किया, एक example दिया बहुत respected lawyer का, that was his individual take. तो आप राम जेठमलानी को उनको सुनिएगा तो आपको मिलेगा दूसरा पर्सपेक्टिव मिलेगा. एंड देयर इज नथिंग राइट और रॉन्ग इन दीज. एथिक्स इज वन थिंग यू हैव टू फॉलो, बट यस आप वो ट्रिक आ जाएगी कि किस क्लाइंट से कितने तक पूछना है, क्योंकि अगर आपको बता ही दिया उसने तो वो भी एक बात है कि फिर आपने एंगेज हुए तो फीस कैसे लेंगे तो किस बात की फीस. एनीवे, सो दिस ईयर्स proposition, Moot proposition, dealing with intersection of constitutional rights and artificial intelligence could not have been more timely or thought-provoking for all of us. It made us grapple with questions that sit at the frontier of modern law. How do we safeguard fundamental rights in an age when technology is reshaping privacy, speech, and human dignity? Human dignity itself in our context is something which should have perhaps been recognized much earlier as part of the core fundamental rights. It has been recognized, nobody can deny, but you have not grown up in that era, but you have grown up, let's say 20, 30 years later. We have grown up in an era when we have seen a police constable slap a rickshaw wala for nothing. The poor man has just made some minor traffic law infringement. क्योंकि वो गरीब था तो उसको थप्पड़ पड़ जाएगा. तब भी अब कस्टोडियल थर्ड वो तो नहीं होते इंटरोगेशन में, थर्ड डिग्री तो कम हो गया. बट दोज डिग्निटी वेयर इट गोज, डिग्निटी इज लिक्विड, इट्स अ फ्लूइड कॉन्सेप्ट, इट इज़ ए इवॉल्विंग कॉन्सेप्ट. जैसे जैसे प्रोग्रेस होगी, विचार हमारे और अच्छे होंगे, सोसाइटी प्रोग्रेस करेगी तो डिग्निटी हायर पेडिस्टल एक्वायर करती जाएगी. आप डिग्निटी से एसोसिएट करने लगेंगे चीज़ों को. अभी डिग्निटी कहाँ है पता नहीं, एक लेवल पे है ज़रूर. बट यस, आर्टिफिशियल इंटेलिजेंस आपको एक नया चैलेंज थ्रो कर रही है. ये इंटरनेट नया चैलेंज थ्रो कर रहा है, क्योंकि पहले कोई अखबार में छापेगा या जैसे हमने आपको एग्जाम्पल दे रहे हैं, एक जगह कोई एक स्ट्रे इंसिडेंट हुआ, बट नाउ इट हैज़ अ पोटेंसी ऑफ गोइंग वायरल एंड द होल फैमिली coming to know of allegations, families, friends, society, before they are actually tested or even taken to courts. Before they go to courts, even if there is an offender, eventually who will be found to be an offender, there is a time gap between the occurrence and the first judgment. But the dignity is gone first day. जिस दिन वायरल कर देंगे उस दिन गई. अब बाद में इनोसेंट कर भी दीजिए, आप किसको किसको जाके समझाएंगे, क्या करें? That is a real challenge for your generation, which we did not have to, if I may say, fortunately did not have to deal with when we set out our journey in this profession. It also brings us to this, a new challenge which is not discussed, but then that is something which is dear to my heart and I will share. Artificial intelligence is very good. It is a term coined. It's whether it is intelligence or not, I will not go into that. But it is a machine process. जो लॉ आप देखेंगे, जो लॉ 50s से इवॉल्व करता हुआ है, चाहे अपने ही सोसाइटल कॉन्टेक्स्ट में, सुप्रीम कोर्ट, हाई कोर्ट्स का देखेंगे, or you will look in different jurisdictions as you will read and rise and grow, you will discover one common thread in all societies which are run by any constitution, that there is a constitutional evolution process that goes on. What is considered right today, don't be sure that this will be right 50 years from now. It may change as you see and read in newspapers that the Supreme Court, which lays down the law for the country, itself entertains a doubt, changes the law by constituting. There's a process, they constitute a larger constitution bench. I'm deliberately not taking any, citing any judgments. You're aware, but that is not the point. Is law mein kiya ki kya kiya? I don't want to discuss any particular law. What I'm trying to indicate is, evolution jab ho raha hai, please think who is evolving? The human thought process. कौन trigger दे रहा है उसको? The society. What happens in the society? That is the trigger point. Who is doing it? Bringing it forward? The lawyer, represented by lawyers. Who does that distillation and refinement and evolution therefore? The judges. So it's all 100% core human activity. That is what brings me back to what artificial intelligence can do. Over-reliance. Artificial intelligence is learning very fast of what is there already. But it will never be able to learn what changes brought what evolutionary steps. It happens. So over-reliance on artificial intelligence, which is being championed as the savior of human race, potentially, but it may also turn out to be a very, very dangerous experiment. But never given any room to artificial intelligence, whether it is even now, it is so dangerous that even if you do a Google search, it's artificial intelligence has stepped in there. And with passing years, it's going to grow. So what you may then rely on is what Brother Justice Ajay Bhanot was suggesting, and Brother Justice Siddharth has also referred to that. Read on your own. Read on your own what is written by the human minds, not what is written by machines over internet. Go by the book written by a human hand. That is what will bring you to understand and that what the changes are or required or how to reason what to do. Artificial intelligence may either make things static because it may learn up to a point and then become hardened, yahi karna hai, not evolve, or take us on a path where we don't know where we are going, but we will travel nevertheless. Because if you argue on the strength of that, you may run the risk of not knowing the real reasons. If the judges have to rely on that, well, that is not going to happen, but equally dangerous or more dangerous. Coming to the contest itself, so as my thoughts are that you don't choose your facts, and therefore you cannot innovate beyond a point. So there comes room for humility again, that has been spoken of earlier by Brother Justice Bhanot. I'll only say what I recently read at one place. It's an unknown author. It says, pride recognizes who is right, but humility will recognize what is right. Go by what is right. Just look at whatever case comes to you. You win it, all right. You lose it, all right. Shouldn't make a difference. To that extent, the lawyer may remain closer to being a saint in his approach. Either case, whatever you charge by way of fee, it's going to come to you. Never go for a win and as a parameter of your success. Never, ever. That is what Brother Justice Siddharth had also referred to. कोई client उनसे जब वो कोई मुकदमा उन्होंने करा other side का, just be right in your approach and accept it. If you are 100% thorough in your approach and you come back home, whether you have won or you have lost, you still will have your own family. And I hope younger generation, yes, on the lighter side, I hope you will all have families very soon. Profession doesn't compete with family. Family is your real, what we say, the real life. Profession is a means to sustain that real life. And also part of our nature, as we have a living example sitting right in front, who will honor all his family obligations, our elder brother Justice Arun Tandon, but he'll find enough time for other things as well. Do it. But don't make the profession your life. Don't make that mistake ever. Even the practicing lawyers here, the younger ones, especially. Senior ones are out after money, so they can go after money, no problem. They can go after money because they were not finding enough philanthropic activities as Justice Arun Tandon has found. So that is your choice. बाकी तो इन लोगों को contribute तो करना ही चाहिए. 50-60% earning हर महीने की कहाँ जानी चाहिए? Philanthropic activities. But then that's all right. But younger lawyers keep that in mind. Family doesn't compete with your profession. Rather, you work hard because you have a family, and it's the family that must get your completely devoted attention once you're out of a work situation. So look at cricketers as they do. Last is a word for all the girl power that we have on display here. What a wonderful time to have this moot court at this girls' college. The Indian women cricket team has already done us proud. And certainly, we are sure that all the girls here, whether they are part of the law college or they were the NCC cadets, truly awe-inspiring and truly commendable, and all credit to the students as also their mentors, their teachers, their principal, and the committee. So all the best to you for a very bright future, a very healthy life, and may you quickly achieve a balance between professional and personal life. Thank you so much. Jai Hind.
धन्यवाद सर. आपका सरल व्यक्तित्व आपके उद्बोधन में अभिव्यक्त होता है. सर, आपने युवा अधिवक्ताओं का तथ्यों की समुचित जांच, सम्यक उपयोग पर ध्यान केंद्रित किया. साथ ही डिजिटलाइजेशन व एआई को समस्या और समाधान दोनों ही रूपों में व्याख्यायित करते हुए उनके प्रति सतर्कता बरतने की सलाह दी. सर, आप अपने वक्तव्य से हमारे मस्तिष्क में सदैव दैदीप्यमान रहेंगे, किंतु महाविद्यालय आपके मस्तिष्क में जीवंत बना रहे, इस उद्देश्य से महाविद्यालय आपको स्मृति चिन्ह भेंट करना चाहता है. महाविद्यालय की उप प्राचार्य प्रोफेसर मंजरी शुक्ला मैम से अनुरोध है कि आप सर को स्मृति चिन्ह व अंग वस्त्र भेंट कर सम्मानित करें. डॉक्टर निशी से समन्वयक वाणिज्य संकाय से निवेदन है कि आप मैम को समुचित सहयोग प्रदान करें.
Thank you, everyone. The Institute is also deeply fortunate to have Mrs. Monica Singh wife of Honorable Mr. Justice S.D. Singh, as a guest in the award ceremony, and the Institute would like to present her with a token of gratitude. I request Dr. Preeti Yadav, Assistant Professor, Department of Sociology, to kindly do the honors.
कार्यक्रम की परिणति से पूर्व हम अपने इस प्रतियोगिता की विजेता व उप विजेता टीम से यह अनुरोध करेंगे कि आप मंच पर एक सामूहिक चित्र हेतु आमंत्रित हैं। माननीय अपनी ट्रॉफी व फ्लेक्स के साथ मंच पर आएं। विजेता और उप विजेता टीम, माननीय मुख्य अतिथि महोदय एवं विशिष्ट अतिथि महोदयों, महाविद्यालय की प्राचार्य, जस्टिस गोपाल जी मेहरोत्रा राष्ट्रीय मूट कोर्ट प्रतियोगिता के कार्यकारी अध्यक्ष श्री न्यायमूर्ति श्री अरुण टंडन सर से निवेदन है कि आप मंच पर आएं। इस प्रतियोगिता में बेस्ट रिसर्चर, बेस्ट स्पीकर एवं बेस्ट मेमोरियल अवार्ड प्राप्त करने वाले प्रतिभागियों से भी निवेदन है कि आप मंच पर आएं अपने ट्रॉफी, फ्लेक्स व चेक के साथ। माननीय न्यायमूर्ति श्री अरुण कुमार सर से निवेदन है कि आप मंच पर आएं। विधि संकाय के समस्त शिक्षकों से अनुरोध है कि आप मंच पर आएं।
now the entire thing is over, I have to make a confession. Confession that when I was a lawyer, I never prepared the case like these young lawyers, upcoming lawyers have prepared. They were so well prepared with the relevant case laws and the facts of the case that we were simply amazed, and we don't know whether we choose the right team or not, but all of them were winners. The way they have presented their arguments. In our time, there was no moot court, but I must say that the young generation is better prepared than we were prepared at our time. So my good wishes, blessings, and everything which you deserve in this life should come to you. Best of luck. Thank you.
With this, we conclude the two-day litigative fest, and I request Professor Rachna Anand Gaur to extend the vote of thanks.
Justice Gopalji Mehrotra, नेशनल मूट कोर्ट कंपटीशन के आयोजन का यह तीसरा अवसर है। विगत 2 वर्षों से यह आयोजन हम सफलतापूर्वक संपन्न कर रहे हैं। यह हमारा सौभाग्य है कि आज के इस आयोजन में मुख्य अतिथि के रूप में हमारे बीच इलाहाबाद उच्च न्यायालय के माननीय न्यायमूर्ति श्री सौमित्र दयाल सिंह उपस्थित हैं। अपने विवेकपूर्ण निर्णयों के लिए विशेष रूप से लोकप्रिय श्री सौमित्र दयाल सिंह इससे पूर्व इलाहाबाद उच्च न्यायालय में लंबे समय तक अधिवक्ता के रूप में कार्य कर चुके हैं। टैक्सेशन, इंडस्ट्रियल लॉ, कंपनी लॉ के क्षेत्र में आपको विशेष महारत हासिल है। आप 2013 में इलाहाबाद उच्च न्यायालय के वरिष्ठ अधिवक्ता के रूप में नामित हुए और 2018 में इलाहाबाद उच्च न्यायालय के माननीय न्यायमूर्ति के रूप में आपने पदभार ग्रहण किया। अपनी न्यायिक व्यस्तताओं के बावजूद आपने हमारे आमंत्रण को स्वीकार किया। ध्यानपूर्वक हमारे प्रतिभागियों के तर्कों को, उनकी दलीलों को, उनके बहस को लंबे समय तक सुना। आपके उद्बोधन से, आपके निर्णय से, आपके हस्तक्षेप से हमारी छात्राओं ने बहुत कुछ जाना, समझा और सीखा। मातृशक्ति को आपने एक नए विश्वास से अपने उद्बोधन में संपन्न किया। हम आपके प्रति हार्दिक आभार व्यक्त करते हैं। हमारे बीच उपस्थित हैं ऑनरेबल जस्टिस अजय भनोट, सिविल, क्रिमिनल, कॉन्स्टिट्यूशनल, टैक्स, सर्विसेज और कंपनी लॉ आपकी वकालत के विशेष क्षेत्र रहे हैं। आप समय समय पर भारत सरकार, उत्तर प्रदेश सरकार और उत्तर प्रदेश पब्लिक सर्विस कमीशन के काउंसिल में रह चुके हैं। 2015 में आप इलाहाबाद उच्च न्यायालय के वरिष्ठ अधिवक्ता के रूप में नामित हुए और 2019 में आपने माननीय न्यायमूर्ति के रूप में पदभार ग्रहण किया। आपके प्रेरक उद्बोधन से हमें विश्वास है कि वो नवागत छात्र छात्राएं जो वकालत के पेशे में जा रहे हैं, उन्होंने सचमुच प्रेरणा ग्रहण की होगी। आपकी उपस्थिति से हम गौरवान्वित हैं। हम आपके प्रति आत्मीय आभार व्यक्त करते हैं। ऑनरेबल जस्टिस सिद्धार्थ गोंडा सिविल सीनियर डिवीजन के और सुल्तानपुर जूनियर डिवीजन के सिविल जज के रूप में भी कार्य कर चुके हैं। आप रायबरेली के जुडिशियल मजिस्ट्रेट के रूप में भी कार्य कर चुके हैं। महाविद्यालय आप पहले भी आ चुके हैं। आपने अपने उद्बोधन में जिस मानवीय संवेदना की बात की वो सचमुच किसी भी पेशे के लिए बहुत महत्वपूर्ण है। हम आपके प्रति हार्दिक आभार व्यक्त करते हैं। इस बूट कोर्ट कंपटीशन को में एक महत्वपूर्ण भूमिका का निर्वाह करने वाला हमारे निर्णायक मंडल, जिन्होंने हमारे प्रतिभागियों के प्रति प्रश्नों को पूरे मनोयोग से सुना और इस कंपटीशन को, इस प्रतियोगिता को एक निश्चित परिणाम तक, एक निश्चित निर्णय तक ले जाने का श्रम साध्य कार्य किया। आप सबके प्रति बहुत बहुत आभार। नेशनल लॉ कॉलेजेस के साथ ही देश के भिन्न भिन्न प्रदेशों के प्रतिष्ठित लॉ कॉलेजेस से आई हुई हमारी 16 टीमें, उसमें प्रतिभागिता करने वाले हमारे होनहार युवा साथी, आप सबको बहुत बहुत बधाई। विजेता टीम को स्पेशल बधाई। जीत का उल्लास आपकी आगामी सफलताओं के लिए आपको ऊर्जा प्रदान करे, इसलिए पुनः पुनः आप सबको बहुत बहुत बधाई। इस आयोजन के सूत्रधार आदरणीय अरुण सर, हम सब जानते हैं कि सारी व्यवस्था का आधार ही आपसे है। अरुण सर के निर्देशों के अनुपालन में निरंतर तत्पर, निरंतर संलग्न हमारी प्राचार्य प्रोफेसर लालिमा सिंह, लंबे समय से इस आयोजन की देख रेख में लगी हुई हंसिका मैम, उनके निर्देशन में कार्य कर रही पूरी लॉ फैकल्टी के सभी युवा साथियों के प्रति बहुत बहुत आभार। दर्शक दीर्घा में उपस्थित सभी सम्मानित अतिथियों के प्रति आभार। ऑनरेबल जस्टिस अरुण कुमार जी के प्रति, मिसेस दयाल के प्रति, इलाहाबाद उच्च न्यायालय के सम्मानित अधिवक्ताओं के प्रति, आदरणीय पुष्पेंद्र सिंह जी हमारे बीच उपस्थित हैं, मिस्टर अभि टंडन उपस्थित हैं, आप सबके प्रति आभार। सुप्रीम कोर्ट से हमारे बीच मिस्टर अभि टंडन उपस्थित हैं, आपके प्रति आभार। सारस्वत खत्री पाठशाला सोसाइटी के सभी सम्मानित सदस्यों के प्रति, बसंत खन्ना जी के प्रति, महेश जी कपूर के प्रति, मिसेस कपूर के प्रति, अमित खन्ना जी के प्रति, आप सभी के प्रति बहुत बहुत आभार। उपस्थित छात्र छात्राओं के प्रति और उपस्थित सभी के प्रति एक बार पुनः पुनः आभार। बहुत बहुत धन्यवाद।
धन्यवाद मैम। कार्यक्रम अपनी परिणति की ओर उन्मुख है। अगले वर्ष हम पुनः एक नए विषय पर युवा प्रतिभाओं व जिज्ञासाओं के साक्षात्कार के उद्देश्य से एकत्रित होंगे। इस आशा के साथ आप सभी का आभार एवं धन्यवाद व सभी से निवेदन है कि राष्ट्रगान हेतु अपने स्थान पर खड़े हो जाएं। सांस्कृतिक समिति से निवेदन है इस कार्य में सहयोग प्रदान करें।
जनगण मन अधिनायक जय हे भारत भाग्य विधाता। पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा। विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा। तव शुभ नामे जागे तव शुभ आशीष मांगे। गाहे तव जय गाथा। जनगण मंगलदायक जय हे भारत भाग्य विधाता। जय हे जय हे जय हे जय 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 हे।
I request our guests and participants to kindly proceed to the lawn for high tea. Participants are requested to gather in the auditorium, stairs of the auditorium for a group photography.